it reinforces the need for environmentally friendly technologies. This is where our future lies. As I said before, and I will tirelessly repeat it again, we must seize the energy opportunity or fall drastically behind. And I want to thank all the witnesses again for being here, and I look forward to hear for your views on the bills that we are considering today. With that, I'll yield back the balance of my time. And now I am going to recognize the ranking member for 5 minutes for the purposes of opening statement.
Chairman Rush, thank you very much, and we certainly appreciate the witnesses being here with us this morning as we explore two pieces of legislation that I think all of us would agree have great intentions. And I think it's important, because this legislation is so important, that we listen to some experts today about some concerns that certainly I have about this legislation, although I agree with the intent of the legislation. For example, on 4678, which holds foreign manufacturers accountable in the U.S. for selling products that comply with our safety standards and require them to have an agent for service of process. I don't really have any problem with that, but I think we have to explore. For example, in 2002, the Congress passed the Public Health, Security, and Bioterrorism Act. And under that act, under certain circumstances, certain companies had to have registered agents. The U.S. Customs law already requires agents for companies that do business in the U.S. in certain instances. We are a signatory to the Foreign Sovereign Immunity Act, and we know that in many countries around the world, like China, a lot of those companies are owned by the government. And it raises the issue, even if you have a service of process, you obtain a judgment, can you really collect on it because of sovereign immunity and so forth. And then we have the Hague Convention on the Service Abroad of Judicial and Extrajudicial Act. And what does the impact of this have on that? So we have a lot of mechanisms already in place through the government to ensure the people of America that we are dealing and consuming and using safe products. Now, I'm not saying that those are enough, but I also know that if we adopt this kind of legislation, we might also expect that other countries may also adopt it, which could have some negative impact on our small exporters that are trying to open up foreign markets. And I know that President Obama, one of his goals is to significantly increase our exports. So all of these are issues that I think we have an opportunity to work together here, but I think it's important that we explore the ramification of this legislation. And so we look forward to the witnesses' testimony on that issue. On the Clean Energy Technology Manufacturing and Export Assistance Fund, I think all of us are certainly interested in exporting green technology or clean technology. And I know already the Department of Commerce has an extensive assistance program to encourage exports of U.S. products. And it appears that this legislation would simply be carving out clean energy technology, which is fine. But as I was reading this legislation, just to give you an example of one thing I was concerned about, because I am from a coal state, coal still provides 51% of all electricity produced in America, and I don't think anyone believes that renewable energies or wind power or anything else, I guess they're one and the same, over the immediate term will come close to providing our electricity needs. But if this bill became law, for example, I would like to see some assistance given to carbon capture and sequestration technology, because China is using more coal every day than the United States even thinks about. And right now, they're just burning coal, low-grade coal, and polluting the environment. And if we can export clean coal technology to them, that would be great. But as I read this legislation, it says to be eligible for this program, the project or the entity has to do one of the following: generate electricity. Well, carbon capture and sequestration does not generate electricity, but it removes carbon dioxide. Second thing, substantially increases the energy efficiency of buildings, industry, or agricultural processes. Well, I'm not sure that carbon capture and sequestration, for example, would meet that criteria. Or it substantially increases the energy efficiency of the transportation system. So those are simply some questions that I think we need to explore, because this is very important legislation, has great goals, and I think we have an opportunity here to explore a lot of these issues and come up with a proposal that all of us can agree to. And I yield back my 14 seconds, Mr. Chairman.
The chair thanks the gentleman. The chair now recognizes the gentlelady from Ohio, Ms. Sutton, for 2 minutes.
I thank the chairman for holding this hearing, and I think both of these pieces of legislation are important. I am proud to be the sponsor of H.R. 4678, along with 61 co-sponsors from both sides of the aisle. I'm going to keep my remarks limited to that at this point. Every year, many Americans are injured, sometimes fatally, by dangerous products that have been manufactured abroad and imported into the United States. Recent examples include toxic drywall, faulty infant cribs, lead paint in children's toys, and defective tires. These products not only hurt American consumers, they hurt American businesses. U.S. manufacturers are responsible for ensuring that the products that they put on the market are safe. Yet it's extremely difficult for injured parties to hold foreign manufacturers accountable because they're unable to serve process or establish jurisdiction. As a result, American consumers and businesses are forced to engage in cost-prohibitive and time-consuming international legal battles, rarely receiving the redress they deserve. The Foreign Manufacturers Legal Accountability Act would require foreign manufacturers doing business in the U.S. to identify a registered agent authorized to accept service of process on behalf of that manufacturer. Registering an agent would constitute an acceptance of jurisdiction of the state in which the agent is located. This bipartisan bill would help protect American consumers and businesses from defective products manufactured abroad. It would level the playing field for American manufacturers and provide U.S. consumers with the necessary tools to seek proper redress. And I want to thank my colleague and co-sponsor, Representative Mike Turner, who is here this morning, for his work and support on this legislation. I also want to thank Representative Linda Sanchez for her leadership and work on this issue, and she may be joining us as well. I look forward to hearing from the witnesses and to working through whatever concerns that the ranking member may have to a solution on this very, very important work. At the end of the day, this is about fairness and justice. American consumers and businesses deserve both, and this legislation will help us achieve that. And I yield back.
The chair now recognizes the gentleman from Ohio, Mr. Lala, for 2 minutes. Lala.
Thank you, Mr. Chairman. Ranking Member Whitfield, thank you for holding this hearing today on these two pieces of legislation, both relating to manufacturing. My congressional district is heavily based in manufacturing, and I am constantly advocating for ways to assist these manufacturers to remain in business and continue producing goods. According to the National Association of Manufacturers, my district is the largest manufacturing district in the state of Ohio, 20th largest in Congress. When I was first elected in December of 2007, represented the 9th largest manufacturing district, and in 2 years have dropped to 20th. The current unemployment rate in Ohio is just under 11%, and there are many counties in my district that have over 12% unemployment. And looking at these two pieces of legislation, the subcommittee needs to ensure that it does nothing to hinder further economic growth to put further restrictions on U.S. manufacturers. It is important that Americans have safe products for use and that companies comply with U.S. safety standards. However, I have several concerns with H.R. 4678, and that will have unintended consequences on American manufacturers. There are concerns that under this bill, the U.S. companies that have contracted with foreign manufacturers for parts will be the ones responsible for establishing a registered agent on behalf of the foreign supplier. In addition, I have concerns that other nations will reciprocate similar laws that would impose additional compliance regulations or liability exposure to U.S. exporters abroad. The manufacturers in my district cannot withstand either of these scenarios. Many of these companies are still holding on by their fingernails in this troubled economy and have great fear they will not be able to withstand further government mandates or increased exposure to liability. I have concerns that this legislation could inadvertently lead to an increase in lawsuits on our manufacturers. My district is also home to many facilities relating to alternative energy sources. Clean energy technology manufacturing is important and is an important piece of the puzzle for America's energy independence. As with all of our manufactured products, exporting is a key to the U.S. to remain a world leader. However, I do have concerns with H.R. 5156 and its creation of another new government program administered by the International Trade Administration within the Department of Commerce. At a time when our national debt is skyrocketing, I do not believe that expanding our government but should be trying to limit it. Also, there are concerns that this new grant program duplicates other programs that have already been created through the energy and stimulus bills. I look forward to the hearing today, and I yield back. Thank you.
The chair now recognizes Ms. Matsui for 2 minutes.
Thank you, Mr. Chairman, and thank you for calling today's hearing. I first of all want to applaud my good friend Representative Sutton for introducing H.R. 4678, and I support her legislation. I'd also like to thank our witnesses for being with us here today, and I particularly want to welcome our witness from the Sacramento area, Jack Crawford, CEO of Jadoo Power. Under Jack's leadership, Jadoo Power is a leader in manufacturing clean energy technologies and in providing hybrid fuel cell power for military, government, and commercial applications. Jack has a wealth of expertise in the clean energy sector, and I look forward to hearing from him today. As he can attest, the Sacramento region is well positioned to be a leader in producing clean energy technologies, with more than 110 clean tech companies that focus on production of fuel cell technology, biofuels, solar, wind energy, and others. To continue growth, the U.S. clean energy sector, particularly small and medium-sized firms, need manufacturing export assistance to boost their competitiveness in the international marketplace. In fact, our nation's clean tech industry is lagging behind many of its competitors in exports, including Germany and China. This is simply unacceptable. The U.S. must be a leader in manufacturing and exporting clean technologies. That is why I, along with Chairman Rush and Dingell and Representative Eshoo, introduced H.R. 5156, a bill to boost the competitiveness of American-made clean tech products both here in the United States and around the world. The bill will create a fund to develop and sustain a national clean energy technology export strategy to provide U.S. clean tech firms with export assistance in finding and navigating foreign markets to sell their goods and services to new customers. The President has laid out a laudable goal to double U.S. exports over the next 5 years, and this legislation will ensure clean energy exports are at the forefront of our national export strategy. The bill will also strengthen America's domestic clean tech manufacturing industry. Ultimately, H.R. 5156 will enhance our standing in the race to be the global leader in clean energy. The BP oil spill only underscores the need for leadership in the clean energy market, and this bill will send a strong message that America is serious about being the leader in producing and exporting these technologies. I look forward to working with my colleagues on the committee to achieve this goal, and I thank you again, Mr. Chairman, for holding today's hearing. Thank you, and I yield back the balance of my time.
Dr. Gaming is recognized for 2 minutes.
Mr. Chairman, I want to thank you for calling today's hearing on 2 pieces of legislation, H.R. 4678 and 5156, to allow us to hold a discussion on important issues facing consumers as we strive to create jobs. I believe that both these bills are well-intentioned as they attempt to assist consumers and improve the clean technology trade deficit that we currently face. Unfortunately, I believe that both bills will have unintended consequences that could prevent them from accomplishing their respective goals. Mr. Chairman, H.R. 4678 seeks to rectify the problems that have been associated with foreign product recalls. While I'm saddened by what has occurred to the victims, one of whom is on our first panel of witnesses, I fear that H.R. 4678 will not fully address the underlying issue. The purpose of this legislation is to hold foreign manufacturers responsible for the products that come to the United States. However, one unintended consequence is that many times domestic companies contracting with foreign manufacturers will likely be responsible for establishing registered agents, thereby putting American companies at risk as opposed to their foreign counterparts. I have similar concerns with H.R. 5156. During the budget window of this bill, we provide $75 million in funding instead of tackling two of the biggest problems with our clean technology trade deficit. Mr. Chairman, the first deals with the raw materials available domestically to support innovation in clean technology. The minerals needed to commercially manufacture these products are either not abundantly available in the U.S. or current policies prevent them from being mined properly. The other problem is the issue of trade. Without access to markets, without burdensome tariffs, we will continue to trail our competitors when it comes to clean technology products. Unfortunately, I do not believe that H.R. 5156 will ultimately alleviate the trade deficit we face in this area. Mr. Chairman, despite my concerns about these bills, though, I do look forward to hearing from both panels of witnesses so they can provide us with their expertise on these matters. And I yield back.
The chair now recognizes the chairman emeritus for the full committee, the gentleman from Michigan, Mr. Dingell, for 5 minutes.
Mr. Chairman, I thank you. I commend you for holding today's hearings on H.R. 4678, the Foreign Manufacturers Legal Accountability Act, and H.R. 5156, the Clean Energy Technology Manufacturing and Export Assistance Act. The former will help ensure foreign manufacturers are held accountable for injuries their products may cause to American public health and safety, and the latter will bolster the nation's exports in the growing sector of green technology. Both are important, and I support efforts such as these and will welcome the input of our witnesses. Before concluding my remarks, I wish to say a few words in support of H.R. 5156, which you, Mr. Chairman, Congresswoman Matsui, and I are original sponsors. There is broad agreement that the United States lags behind other nations in terms of exports. Whereas exports account for 49% of Germany's GDP, they account for only 9 to 13% of our own. More alarmingly, while Germany exported $19.6 billion in clean technologies and services between 2004 and 2008, the United States exported only $7.7 billion. In brief, the United States consumes far more than it produces, and in so doing is squandering not only our valuable resources, our monies, but our opportunity to be a leader in green technology exports. H.R. 5156, by establishing a modest support mechanism for the export of such technologies by U.S. manufacturers, will significantly help remedy this matter. Moreover, the tax revenue generated from these exports will pay more than the bill's cost over a 5-year period. The bill should enjoy bipartisan support and must be recognized as a critical component of our nation's economic recovery. And to return to H.R. 4678, it should be noted that had such legislation been in effect, our troubles with the matter of Toyota vehicles and their safety consequences would have been handled much easier. Mr. Chairman, I thank you, and I yield back the balance of my time.
The chair recognizes the gentleman from Louisiana, Scalise.
Thank you, Mr. Chairman. Thank you. I'd like to focus my comments on H.R. 4678, the Foreign Manufacturers Legal Accountability Act, a bill that is relevant to my state and district because of the problems we're experiencing with toxic drywall. To date, the Consumer Product Safety Commission has received over 3,300 incident reports related to toxic Chinese drywall from 37 states. 20% of these reports are from Louisiana, which is second only to Florida, and my office continues to receive complaints from constituents affected by toxic drywall. Last week, a resident of New Orleans contacted my office at a loss for what steps to take or what to do for help. Like many others, her family was forced to move out of their home because of toxic Chinese drywall, and they can no longer afford to pay the mortgage on a home they aren't occupying while paying rent for temporary housing at the same time. The CPSC has been investigating toxic Chinese drywall for over a year and a half, and it has sufficient evidence that toxic drywall manufactured by Chinese companies is responsible for the severe damage we have seen in thousands of American homes. Last month, the Commission even identified 10 drywall manufacturers whose products emitted high levels of hydrogen sulfide in laboratory testing. Unfortunately, no action has been taken against these companies. We must hold the manufacturers of toxic Chinese drywall accountable, and I have continued to push for this, including requesting that the Department of Homeland Security pursue any and all options available to the Department, including the seizing of assets being shipped into the United States against those entities that manufactured toxic Chinese drywall and have been found liable for the damages associated with their contaminated products. These foreign manufacturers bear responsibility for serious damage to thousands of homes across the country and have caused homeowners significant financial hardship and in some cases physical harm. Even more concerning is that they have done so without repercussion. We must take action to hold accountable those who are responsible for the damages caused by toxic Chinese drywall until they settle with the affected victims or comply with the rulings of U.S. courts. Given the challenges we're facing in doing this, I'm pleased to see some of my colleagues recognizing this issue. The goals of H.R. 4678 are good, but I do have questions about whether its implementation will accomplish its intentions. While it can be argued that this bill would make it easier to prosecute foreign manufacturers in the U.S., foreign courts would still be under no obligation to enforce such judgments. We would still be dependent on the goodwill of foreign courts to enforce those judgments. My constituents and others around the country who have been affected by toxic Chinese drywall deserve answers and solutions, and this subcommittee must work with the Intergovernmental Task Force on Problem Drywall to help deliver that. Thank you, and I yield back.
Mr. Barrow is recognized for 2 minutes. The chair now recognizes the gentleman from Iowa, Mr. Braley, for 2 minutes.
Thank you, Mr. Chairman, for this important hearing. And as chairman of the Populist Caucus, I'm proud that the bill known as H.R. 4678, the Foreign Manufacturers Legal Accountability Act, is part of our America Jobs First platform. This bill requires foreign manufacturers doing business in the United States to identify a registered agent authorized to accept service of process on behalf of the manufacturer. And one of the reasons I support this legislation is because, unlike a lot of people at this hearing, I've actually tried to hold foreign manufacturers accountable for their defective products in U.S. state courts. It's virtually impossible. There are companies marketing products in this country who put the word USA in their company logo and put out publications that say, in an industry dominated by foreign competition, we're proud of the fact that our products are manufactured right here in the United States, and yet when those products gave rise to a defect and a suit was pursued, they turned around and said these products, in fact, were not made in the United States, they were made in China, which then dumps you into the bottomless pit of attempting to get suit on an entity that may be a part of the Chinese government who is manufacturing that defective product. So you can imagine how difficult it is when you have to translate that document into the native language of the country where the suit is being served, then get help from a government entity that may be unwilling to subject its manufacturers to liability in U.S. courts, and after all those delays, nothing happens. And that I've heard some of my colleagues express concerns about U.S. companies being exposed to increased litigation. They are not well-founded concerns, because the reality is right now in many states, if you cannot find the manufacturer of a defective product and hold them accountable, then some of the immunity that goes to the distributors of those products, if the manufacturer is available and can be pursued in that state court, go out the window, and then the U.S. distributors and manufacturers are the one on the hook. So this bill actually is a great thing for U.S. manufacturers. It levels the playing field and gives them the same opportunities to compete with foreign manufacturers that U.S. companies have. So that's why I support it, and I yield back.
The chair now recognizes the gentleman from Florida, Mr. Stearns, for 2 minutes.
Mr. Chairman, thank you very much. Having chaired this committee in the when Republicans in majority, we tried to wrestle with this problem of reciprocity between countries where there is fraud, abuse, incompetence, intentional mislabeling, and things like that. Mr. Braley mentioned one of the problems that we ran into. We never got to the point where we were able to get together a bill that would deal with this very serious problem. It affects not only manufacturing, but also the Internet, how to go after people that are fraudulent on the Internet or basing their companies outside the United States. So I think the bill is well intended. I think the hearing will be worthwhile listening to. But I have to tell you that I don't think the problem that Mr. Braley talked about is going to be solved here, because this agent is going to be sort of like a cardboard agent where you'll deliver all these documents that are in English and he'll just dead file them. I think this registered agent, will be there, but I think we might even have to explore some other way to have reciprocity between countries, because that's the larger issue, because a lot of these countries are going to just stonewall us. Can we hold foreign manufacturers accountable for harmful products? Foreign courts are under no obligation to enforce U.S. judgments. So I welcome this hearing, Mr. Chairman. I look forward to what they have to say. I just conclude with H.R. 5156, the Manufacturing and Export Assistance Act, Clean Energy Technology. This is going to cost us money. This is questionable. I would think all of this, Mr. Chairman, was in the cap and trade, which passed out of the House. Perhaps it's also in the stimulus bill. So, I think we have to realize that if we didn't get everything together in that cap and trade, I'd be very surprised. There were hundreds of amendments, and we discussed it for a week. So I would think a lot of this was there. I just conclude, where are you going to get all this clean energy technology parts from? So I think it's worthwhile to have these hearings on these two bills. I just think we perhaps might need to, when we mark this up, to make it a little bit stronger. Thank you.
It is at this time. It is at this time that I'm going to entertain UC requests that two individuals who are not members of the subcommittee be allowed to sit in on the subcommittee, to have opening statements, and to question the witness, to have full authority on the subcommittee for the purposes of this hearing. And those individuals are Ms. Sanchez of California and Mr. Turner of Ohio. Hearing no objections, so ordered. Now we will go back to the regular order of business, and we'll recognize Mr. Terry for Ms. Sanchez is recognized for 2 minutes for the purposes of opening statement.
Thank you, Mr. Chairman and distinguished members of the committee, and I appreciate you allowing me to participate with the subcommittee today. And I apologize that I'm not going to be able to stay for the entire time, but the committee that I serve on is currently holding a hearing as well. I want to share my support for the Foreign Manufacturers Legal Accountability Act that was introduced by my good friend Congresswoman Sutton from Ohio. I'm an original co-sponsor of this piece of legislation, and I introduced similar legislation in the last session of Congress, and we held hearings on that in the Judiciary Committee as well. I've long been alarmed by the steady stream of toxic or defective foreign manufactured foods and products that harm U.S. families every year. Beyond the risk that these products pose to our health and welfare, I'm also concerned that many foreign manufacturers have gained an unfair advantage over U.S. manufacturers by avoiding liability for the injuries and deaths that their products cause. Because of the difficulties associated with serving process on and establishing jurisdiction over foreign manufacturers, many Americans that are harmed by defective foreign-made products have no recourse. They literally never get their day in court. The Foreign Manufacturers Legal Accountability Act amends current law to facilitate service of process on foreign manufacturers. Quite simply, it just requires manufacturers who want to put their goods in our stream of commerce to establish a registered agent in the United States who then can be served process. That simple requirement, just making sure that they are servable if injuries should arise, will level the playing field for U.S. manufacturers by eliminating the unfair competitive advantage enjoyed by foreign manufacturers. This would essentially put them on equal footing, making sure that all companies, whether foreign or domestic, are held accountable for the harm that they cause to American consumers. I want to thank the chairman for calling this hearing, and I'm pleased that the subcommittee has taken the time to discuss H.R. 4678. And again, I appreciate the invitation to come, and I yield back my time.
Mr. Terry, you should have been recognized earlier. Please accept the chair's apologies. And now the chair recognizes Mr. Terry for 2 minutes.
Necessary, Mr. Chairman. I appreciate that. And I'm concerned. I'm mostly going to discuss the Foreign Manufacturers Legal Accountability Act as one of the original sponsors, and worked a little bit with Ms. Sutton on this. And I think this is an important piece of the legislation in protecting American consumers from defective goods manufactured outside the United States, in the sense that if they don't have any presence within the United States, there may be very little ability for the victim to be compensated or justice occur, which then falls mostly on the taxpayers then instead of the foreign entity. And all what this does, and Cliff is correct, the gentleman from Florida, that this doesn't really correct that problem, but you can't get to the second hurdle and the third hurdle in this process without being able to effectively hand the petition to a representative of that country. And so this is just setting up the first step here. We do need to continue the dialogue on this, but this seems to be kind of the first step, the easy, non-controversial, or for the most part, the least controversial part of the process. So I want to thank the chairman for holding a hearing on this matter. I'm anxious to hear from the witnesses and receive their input, and I yield back.
Commander Murphy is recognized for 2 minutes.
Thank you, Mr. Chairman. We've now reached a point where China is the largest foreign holder of U.S. debt at $900 billion, and more than 2.3 million U.S. manufacturing jobs have been displaced to Chinese companies that sell products like drywall that causes terrible illness, lead in toys, fungus in diapers, and toxins in baby bottles. I'm thankful we're having a hearing on how to better hold manufacturers of harmful products liable, but the larger issue is how we're going to pursue policies that are going to invigorate American manufacturing in a fair playing field. And if we're going to tame an economic dragon like China, it's not going to be about lofty theories or more government spending, but how to make sure that is a level playing field. I know that along with Congressman Tim Ryan of Ohio, he and I have introduced H.R. 2378, the Currency Reform for Fair Trade Act, which stops some of the unfair trade practices of China, particularly some of their currency manipulation, which we consider vital. As we're looking at legislation that tries to find ways to help promote American businesses, I believe that oftentimes we do not need American businesses to get more ideas on how to wade through complex trade laws, but make sure that we have trade laws that are fair and that they're fairly enforced. Recently, the Steel Caucus, which I'm vice chair, has pushed for and been successful in getting some findings where China has dumped pipe and in the past rolled steel in unfair trade practices. This is what American manufacturers want to see. But we also want to make sure we're having a system whereby we're not setting up laws here such as cap and trade and light bulb laws, which basically turn our jobs over to China. I'm looking forward to hearing some insight from this panel today of how we can make sure we do have fair trade laws and what we're doing, not just to tell American companies how to wade through this complexity, but make sure that they're able to use their ingenuity, their creativity, and their manufacturing skill to bring back American jobs. And I yield back. Thank you.
The chair now recognizes the gentleman from Ohio, Mr. Turner, for 2 minutes.
Thank you, Chairman Rush and Ranking Member Whitfield. I appreciate you allowing me to participate in today's hearing on H.R. 4678, Foreign Manufacturers Legal Accountability Act of 2010. I'm an original co-sponsor of H.R. 4678, and I want to thank my Ohio colleague, Congresswoman Betty Sutton, for her hard work on this important piece of legislation. Representative Sutton has been a steadfast advocate for her community and for manufacturers in Ohio. I also want to thank the U.S. Chamber of Commerce, who's been working with both my office and Representative Sutton's office on H.R. 4678, and I look forward to the continued collaboration as we move forward with this important legislation. The Chamber has expressed concern about a provision that may permit jurisdiction in U.S. courts for non-U.S. matters. It's an unintended consequence, and both Betty Sutton and I are looking at language that could adjust that. In this hearing today, I know there may be other unintended consequences, and look forward to those being addressed. But mostly I appreciate the manner in which Representative Sutton has worked on this in a bipartisan manner and worked with the Chamber to ensure the bill will protect consumers, while at the same time avoid jurisdiction in U.S. courts concerning matters that have not caused injury in the United States. The state of Ohio has faced many challenges as it transitions from being a manufacturing-based economy. Many of our local manufacturers have worked to remain competitive, but find themselves in an uphill battle with some foreign manufacturers because of unfair trade practices. One way in which foreign manufacturers are given an unfair advantage is by their ability to oftentimes avoid the American judicial system. Because service of process and establishing jurisdiction is difficult with these products, maintaining a registered agent in the U.S. will assist American consumers in their ability to redress injuries. And, well, how does it do this? By establishing an agent, it allows U.S. courts to have jurisdiction over the foreign entity and thereby allow them to render a judgment, including the issue of seizing assets. And this will help level the playing field for domestic manufacturers as they also have to avail themselves of the American judicial system. I want to thank you again for the opportunity to participate and for holding this important hearing. I look forward to reading the testimony from the witnesses today and hearing their comments and working with Congressman Sutton on passage of this important legislation. Thank you.
The chair thanks all the members of the subcommittee for their opening statements. And it is now the time for us to hear from our policy experts, our witnesses, who have been invited to testify before this hearing. And let me again welcome you and thank you so much for the extending your valuable time to this subcommittee. And I want to introduce you all, beginning on my left, there's Mr. Jeremy Baskin, who is at the Office of the General Counsel for the U.S. Product Safety Commission. Sitting next to Mr. Baskin is Ms. Amy Gadhia. She's the Policy Counsel for the Consumers Union. Did I pronounce it correctly? Amy Gadhia. Next to Ms. Gadhia is Mr. Bill Morgan. He's a victim of a defective Chinese drywall. And seated next to Mr. Morgan is Professor Andrew Popper. And Professor Popper is a professor of law at the Williams College of Law of the American University. And next to Professor Popper is Marian Rowden. Is that Rowden? She is the president and CEO of the American Association of Exporters and Importers, the AAEI. The chair again welcomes you, and it is the common practice of this committee that all the witnesses be sworn in. So would you please stand, raise your hand, right hand rather. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? Let the record reflect that all the witnesses have responded in the affirmative. And now we will have 5 minutes of opening testimony from our witnesses, beginning with you, Mr. Baskin.
Good morning, Chairman Rush, Ranking Member Whitfield, and members of the Subcommittee on Commerce, Trade, and Consumer Protection. My name is Jeremy Baskin, and I'm a general attorney who works with the Import Surveillance Division of the Office of Compliance of the U.S. Consumer Product Safety Commission. I'm pleased to be here today to discuss the U.S. Consumer Product Safety Commission's efforts in the area of import surveillance and H.R. 4678, the Foreign Manufacturers Legal Accountability Act. Before I begin, let me first note that the testimony that I give this morning is mine and has not been reviewed or approved by the Commission and may not necessarily represent the views of the Commission. From 1998 to 2007, the value of consumer products imported into the United States increased over 100%. During that time period, imports from China nearly quadrupled and now constitute over 40% of all consumer goods. The shift in specific product areas has been more pronounced. In 2002, approximately 60% of toys purchased in the United States were imported from China and Hong Kong. By 2008, that number had risen to almost 80% of the U.S. market. In response to the rapid increase in consumer product imports, the CPSC has taken several steps to inspect products entering the country to ensure that they comply with applicable product safety standards. In 2008, the Commission announced its Import Safety Initiative and established a new Import Surveillance Division within the Office of Compliance. The establishment of this new division allowed the CPSC to co-locate permanent full-time compliance investigators at key ports of entry of the United States. In 2009, the division had 10 full-time employees, FTEs, dedicated to port surveillance. That number is scheduled to rise to 14 FTEs by the end of fiscal year 2010 and 19 by fiscal year 2011. In addition, the division can call on the resources of the entire Office of Compliance, which has over 100 FTEs when necessary. The CPSC has also sought to enhance its relationships with larger agency partners, such as the Department of Homeland Security. Through the Operation Guardian program, CPSC partners with U.S. Customs and Border Protection, CBP, staff in order to leverage joint resources. In addition, CPSC recently assigned 2 FTEs to CBP's new Commercial Targeting and Analysis Center, called the CTAC, and executed a Memorandum of Understanding with CBP that allows the agency direct access to pre-arrival cargo data. This allows CPSC inspectors to target suspect shipments before they arrive, and, most importantly, before potentially dangerous goods can enter the U.S. stream of commerce. We have also conducted training programs with CBP to educate both government personnel and the importing community on CPSC and CBP product detention and seizure authorities. So far, the results of these initiatives are encouraging. In FY 2007, CPSC collected approximately 750 samples of suspect products entering our country. In FY 2009, the number more than doubled to almost 1,600. At the same time, we started to see a commensurate decrease in the number of voluntary recalls from 563 in FY 2008 to 466 in FY 2009. In most cases, CPSC has been able to work with domestic partners of foreign manufacturers, such as importers or retailers, on enforcement activities to obtain relief for consumers without resorting to adjudicative proceedings. In a few cases, however, the lack of a registered agent for service of process has hindered the Commission's ability to develop information that would help us to provide relief to consumers. One example of this is the CPSC's efforts to provide relief to U.S. homeowners impacted by problem drywall imported from China. In a number of cases, CPSC staff has attempted to send requests for information to Chinese drywall manufacturers, only to have these requests returned to the Commission, refused, and unopened. The lack of registered agent for service of process has also been recognized by Chinese industry groups, and some local lawyers in China have provided legal advice seeking to exploit this situation. Thankfully, this type of sentiment appears to be rare. However, it is foreseeable that additional attempts to stymie or obstruct Commission efforts to obtain information voluntarily from manufacturers outside of U.S. legal jurisdiction, and that could occur in the future. Any such recalcitrance could impede Commission efforts to assist consumers with potentially defective consumer products. Additional authority allowing CPSC to require that foreign manufacturers designate a U.S. registered agent for service of process could be helpful in some cases, particularly those involving administrative requests for documents or information. On January 15, 2010, CPSC Chairman Inez M. Tenenbaum noted in a statement accompanying a report to Congress that helpful changes to existing statutes might include service of process requirements for foreign manufacturers so the agency can more easily pursue recalls. Currently, any action against an identifiable foreign manufacturer would require service of process using the Hague Convention. As the subcommittee moves forward, however, some additional direction would be helpful with regard to the range and size of manufacturers that would be subject to the registration process. In addition, it might also be helpful to involve the Import Safety Working Group in this process to ensure that appropriate jurisdictional and operational details are addressed. Mr. Chairman, thank you again for the opportunity to testify. I would be happy to answer any questions at this time.
Thank you. The chair now recognizes Ms. Lahia for 5 minutes.
Thank you. Good morning, Chairman Rush, Ranking Member Whitfield, and members of the subcommittee. My name is Ami Gadia, and I am Policy Counsel with Consumers Union, the nonprofit publisher of Consumer Reports magazine. We appreciate the opportunity to testify today in support of the Foreign Manufacturers Legal Accountability Act. I offer my testimony on behalf of both CU and the Consumer Federation of America. My full comments are contained in my written testimony, but I'll summarize them briefly here. H.R. 4678 is necessary to ensure that consumers who are harmed by unsafe products can obtain redress no matter where the product is manufactured. It will also create a level playing field for all manufacturers, both domestic and foreign, by holding the responsible party accountable when consumers are injured. CU and CFA have long fought for legislation and regulation that will result in safer products on our store shelves. But in the event that an unsafe product makes it into the marketplace, consumers should be able to pursue all remedies for the harm they suffer, whether the manufacturer of the unsafe product is a foreign company or a domestic one. The products that Americans use every day are increasingly being manufactured overseas. According to the Toy Industry Association, in 2007, toys made in China made up 70 to 80% of the toys sold in the U.S. Of the products recalled by the CPSC since 2006, more than 75% of products were manufactured outside of the U.S. We have too many frightening examples in recent years of dangerous or deadly foreign-made products. Melamine, which is toxic to animals, was blended into pet food to give artificially high protein readings. Diethylene glycol, potentially lethal to humans, was substituted for its higher-cost cousin glycerin in the manufacture of toothpaste. Tires were manufactured with either a minimal or missing gum layer needed to prevent catastrophic tread separation. Toxic lead paint was substituted for the paint that was originally approved for popular children's toys, presumably to save money. These are all cases where unscrupulous business practices have jeopardized the health and safety of the consumer. This legislation would assist our federal agencies as well in their ability to recall consumer products manufactured by foreign entities. The following example is illustrative. In May of 2001, the CPSC recalled a home soda machine manufactured by Drinkmaker of Sweden. Components inside the soda machine broke apart and went flying, and there were reports of lacerations, fractures, and contusions caused by the machine. However, the manufacturer, Drinkmaker of Sweden AB, either could not be contacted by the Commission or would not cooperate with the voluntary recall. Fortunately, a responsible company, the Soft Drink Company of Seattle, Washington, agreed to conduct the recall of these machines with the CPSC and to repair the drink maker. It is untenable, however, to have a system of accountability that relies upon this kind of altruistic and rare behavior. By requiring that foreign manufacturers have registered agents in the U.S., H.R. 4678 will make considerable strides in assisting CPSC, FDA, and EPA in holding the appropriate entities responsible for the products they introduce and sell to U.S. consumers. If foreign entities have the benefit of selling products and making profits from sales in the U.S., they should be accountable if the product causes harm. While in some instances, U.S. retailers and other entities have shouldered the burden of the foreign manufacturers for the products they sell,
This cannot be relied upon and is not always fair. Domestic manufacturers who make safe products should not be undercut by foreign manufacturers who are not prioritizing safety. If a foreign manufacturer knows that they cannot be held responsible in U.S. courts for the dangerous products they sell, this knowledge has a likely significant impact upon their manufacturing decisions. Do they use the stronger, more expensive component? Do they ensure that the product meets safety standards? Holding manufacturing entities accountable in our civil justice system acts as an important deterrent to unethical and potentially harmful business conduct. Deterring wrongful conduct is a significant attribute of our civil justice system, and it does not make sense that foreign manufacturers who sell products in the U.S. should be outside of that system. We have a modest suggestion for an improvement to the bill. In Section 3A3 of H.R. 4678, the minimum size of the foreign manufacturer is left to the discretion of the applicable agency. At a minimum, the heads of each agency must coordinate the definition of which companies would fall under the bill's scope, and ideally there will be a consistent definition. It would be confusing and counterintuitive if a manufacturer were to produce some products that fall under the scope of this bill and some products that do not. Further, a consumer could be killed or seriously hurt by a product made by a manufacturer of any size. Our groups understand that it may be necessary to make a determination about which manufacturers fall under the bill, but ensuring that consumers can obtain redress should be prioritized. We want to prevent companies from purposefully using the size limits to evade responsibility to purchasers and users. Finally, we oppose efforts to weaken aspects of this legislation, including efforts to shift cases from state to federal courts. Efforts to limit access to state courts have negative consequences for consumers. Corporations that violate state laws are less likely to be held accountable for their wrongdoing when a federal court hears the case rather than a state court. Further, corporations now seek to avoid responsibility under state law as states enact laws expanding consumer and environmental protections. When a case is based solely on a violation of state law, as many product liability cases are, no compelling reason exists for stripping state courts of the ability to enforce that state law. Consumers Union and Consumer Federation of America support the Foreign Manufacturers Legal Accountability Act, and we look forward to working with you to ensure that this bill becomes law. Thank you.
The chair now recognizes Mr. Morgan for 5 minutes.
Chairman Rush, members of the subcommittee, thank you for allowing me to come here and testify.
Would you please pull the mic closer to you? Thank you.
There we go. Thank you. Thank you for allowing me the opportunity to come here and share my experiences with you this morning. My name is Bill Morgan. I'm a retired police officer after having served the city of Newport News, Virginia for 24 years. My wife, Deborah, is a school teacher. She and I have been married for 27 years and have 2 daughters, and our first grandchild was born a couple of weeks ago. My wife and I bought our dream home in July of 2006. It was a beautiful home on a corner lot in Williamsburg, Virginia, with a big yard. Both Debbie and I fell in love with the home. It was the perfect home for our family. We paid a little under $400,000 for the home. After my wife experienced multiple episodes of nosebleeds and headaches, and after our house had a series of failures with air conditioning and electrical systems, we discovered our home had been built with defective drywall imported from China. We learned that this drywall contains high amounts of sulfur and that corrosive sulfur gases were circulating in our home, corroding our electrical and mechanical equipment. My home was built with almost 200 sheets of 4 feet by 12 feet Chinese drywall. After a hearing in front of Judge Eldon Fallon in New Orleans earlier this year, he found that the electrical and mechanical systems in my home had been completely destroyed and needed to be replaced. The only solution to this extensive damage is to strip my house back down to the studs and completely rebuild it. I can't afford that. The corrosive gases have also damaged my computers, televisions, and other electrical and electronic devices in my home. We were scared for our family's health and concerned about the risk of fire. We moved out of the house in June 2009 last year. Since having to abandon our dream home, I've been unable to pay the rent on the place where we're currently living and my mortgage. I've lost my home in foreclosure, and I've had to file for personal bankruptcy. The company that manufactured the drywall in my home is called Taishan. This company is located outside Beijing in China. Although the Chinese company sent enough drywall into Norfolk, Virginia to build several hundred homes, it has refused to take any responsibility for its defective product. In the complaint that was filed on my behalf, it was necessary to have a lawsuit translated into Mandarin with Special Process Service flying to China utilizing a time-consuming and expensive process. The Foreign Manufacturers Legal Accountability Act would streamline this process and give victims of defective foreign products a more speedy and equitable procedure to have their claims addressed. My lawyers have advised me that they've spent well in excess of $150,000 serving foreign drywall manufacturers for victims like myself. It's not unusual for these foreign authorities to sit on the lawsuits for 6 months before serving them on the defendant manufacturers. The average American, like myself, cannot afford this expensive, time-consuming, and frustrating procedure. Foreign manufacturers should not be allowed to sell products which destroy homes and make people sick with impunity. Unless these companies are required to make themselves amenable to being sued in U.S. court, they should not be allowed to sell their products here. U.S. businesses are required to abide by our laws, and foreign businesses that profit off of U.S. consumers should do so as well. I look forward to answering any questions you folks may have, and thank you for allowing me to come here and share this experience with you here today.
The chair recognizes Mr. Popper for 5 minutes.
Thank you, Mr. Chairman, and a special hello to Congresswoman Sutton and from my alma mater, Baldwin Wallace in Berea, Ohio. H.R. 4678 is a straightforward, appropriate, essential step. It is, as far as I can tell, constitutionally sound, beneficial to consumers, beneficial to U.S. businesses, and consistent with the laws and practices in many of our trading partners. It is, as far as all of the witnesses seem to understand, a way to level the playing field. It strips foreign manufacturers of an unfair advantage. It closes a understandable loophole in our legal system. And it's not a loophole that is illegitimate. There's a constitutional basis for it, but there's also an answer for it. And the answer is this legislation. It begins, at least in terms of how we think about these things, with the obvious need. And I don't think any of us could say it better than Mr. Morgan just did. When you place into the stream of commerce millions of products, and we're talking about millions of products with toxic levels of lead, drywall that is destroying a home and a family, cribs that present a risk of strangulation, aqueducts that are coated with date rape drug as part of their paint, contaminated toothpaste and seafood and honey and pet food, you got a problem. And you might want to think that there are nice ways to get around this, or our existing system of laws will account for it. But you really need to take the bull by the horns here. This is a very wise, very simple piece of legislation. The idea of designating an individual for service of process, and by that designation establishing consent, is, as I think we all said, it's a logical, simple, appropriate, and constitutional approach. Imagine the scenario that was just presented by Mr. Morgan, repeated over and over and over again. The majority of our most common pharmaceutical products manufactured abroad. Crash helmets manufactured abroad. And the list, as you see from my testimony, goes on and on and on. Here is a bill that deals with the problem, finally, of the difficulty of hailing into court, an interesting term, a foreign entity that otherwise has a minimum contacts and reasonability basis for resisting service process. Here is a bill that actually solves the problem. And we all recognize what the problem is. If you don't have an agent or officer in this country, if you don't own property or have a representative in the United States, it becomes difficult under our current system, under our current jurisprudence, to establish in personam jurisdiction. Now, with one simple bill that mimics legislation in other fields, that seems fair, that seems a legitimate quid pro quo, a condition for doing business in the United States that is mimicked in many other areas, you solve the problem. There were other solutions that people thought of, the aggregate of contacts suggestion that comes from the concurring opinion and the plurality opinion in Asahi is a legitimate answer. It's just complicated. This is simple. This is right. And this is the moment to do it. You have foreign producers who are creating a risk and are now being given a simple choice. I like to think of this legislation in terms of that word. This is choice. This is party autonomy. You don't have to do business here. If you choose to do business here, then you're subject to our laws. If we are lucky enough under the other legislation that's being considered or in any other area to have our wonderful manufacturing community able to market its goods abroad, do you think that they would get a free pass from other countries? China has just adopted a comprehensive tort law with strict liability, punitive damages. You think that China is going to recognize a minimum contacts theory and not impose on our companies who do business there the same responsibility that we ought to be imposing on companies who do business in the United States? I don't think so. I don't think so. On the question of trade and on the question of whether this creates an unfair advantage, there was a case involving artificial Christmas trees that catch on fire in the United States District Court about 2 years ago. And that product was manufactured in China, and the court held as follows. In this age of WTO and GATT, it is only reasonable that companies that distribute allegedly defective products through regional distributors in this country anticipate being hailed into court. Well, of course it's reasonable. Of course it's normal. It is a condition of doing business here, and yet a loophole exists. Close the loophole. It's not that complicated. This is leveling the playing field. This is getting rid of a free pass that we are giving foreign manufacturers, a free pass that our manufacturers don't get. The law of the land in this country, the law of the land in virtually every common law country, is lex loci delicti. You apply the law to the place of the wrong. The place of the wrong is here. This is where the manufacturer is harmed. Give the manufacturer the access to our courts, give the harmed individual access to our courts, and let our system of justice work. This is good legislation. It's going to produce fair results. It isn't perfect. No legislation is. The Constitution isn't perfect. That's why we keep amending it. I ask that you give consideration to the bill. Thank you.
Ms. Brown, you are recognized for 5 minutes.
Thank you, Chairman Rush, Ranking Member Whitfield, and members of the subcommittee. My name is Marianne Rowden, and I'm the President and CEO of the American Association of Exporters and Importers. AEI has been the voice of the international trade community since 1921, and we represent the entire spectrum of the trade community. AEI greatly appreciates the opportunity to testify today. Our written testimony submitted for the record raises 5 points, but I would like to concentrate on 2 fundamental issues. Since enactment of the Consumer Product Safety Improvement Act, product safety has become an integral part of trade compliance. This new responsibility follows the trade community adopting new practices to enhance supply chain security since 9/11. Our experience over the last decade has been that regulating goods produced outside the United States requires 2 things. First, a holistic risk management system, and 2, implementation of product safety legislation, which would eliminate the need for H.R. 4678. Let's turn to the chart entitled A Multi-Layered Approach to Holistic Risk Management. This chart categorizes companies based on risk characteristics. This solution will allow the government to spend its limited resources efficiently and effectively to prevent defective products from entering the commerce of the United States, secure the homeland, and increase trade compliance. We would like to highlight that companies who joined CPSC's voluntary partnership program with CBP, the Importer Self-Assessment Program for Product Safety, would fall into the ultra-low-risk category as a result of their demonstrated commitment to ensuring the integrity of their imported products and the safety of U.S. consumers. This holistic risk management approach is critical to the implementation of product safety laws enacted by Congress. First, without information about the integrity of imported products, we will continue to see defective products. AEI is working with CBP, FDA, CPSC, and other federal agencies to leverage the data already collected by CBP to assess risk. Congress has chosen different methods for dealing with risks posed by different products. For consumer products, Congress has directed CPSC to require certifications demonstrating that the product meets applicable safety standards. For food, drugs, and devices, Congress chose to require foreign manufacturers to register with FDA because of the risks posed to the public health by potential bad actors seeking to compromise the integrity of these products. These laws need time for implementation and evaluation of their effectiveness before adding more legislative requirements. Finally, AEI remains concerned that if Congress chooses to pass H.R. 4678, similar requirements will be placed on U.S. companies exporting to foreign markets. We believe that it will be difficult for small U.S. companies to expand export opportunities and create jobs in the United States if they are required to appoint a registered agent in foreign countries to defend lawsuits. We thank you for the opportunity to testify today, and I'm happy to answer the subcommittee's questions.
The chair thanks all the witnesses for their opening statement. And the chair now recognizes himself for 5 minutes for the purposes of questioning the witnesses. Mr. Morgan, I must begin with you. Your story of you and your family, the tragedy that you all had to endure is heart-wrenching. There's not one of us that wasn't moved by the story that you provided us. And I want to thank you for your willingness to share your story with us today. The discovery of defective Chinese drywall in what you thought was your dream home has, you said, that has left your life turned upside down. It's forced you into bankruptcy and forced you to lose your home. And I can't think of anything that would be as horrible as having someone to lose their home under these kind of circumstances. Your story demonstrates quite clearly to all of us that the effects of foreign defective products on the American consumer can be enormous and can be life-altering. We're not only moved emotionally, but we're also outraged by what happened to you and your family and what is happening to not only you and your family, but to thousands of other American consumers who are victims of these defective drywall and other products, I might add, foreign that are defective that come in from overseas. We are just very moved by even the thought that Americans have to suffer from these circumstances. I guess this might be kind of an innocent or elementary question, but can you share how you feel about that and explain why you support this legislation? I mean,
Yes, sir. I bear no ill will to China or the companies. 14 months ago, my life was perfect. We had no concerns, no issues, and in 14 months, I'm here today talking with you good ladies and gentlemen. Just hold them accountable like anybody else in this country. I don't think they should be placed on a higher standard. Just hold them accountable like everybody that does business in this country is. As a police officer, my wife being a school teacher, we always had to obey the rules. It's just our nature. And I think that's probably the most frustrating thing is they're not being made to obey the rules of doing business in this country.
Since your story has been made known to the public, have you been able to identify or share your stories with other American citizens who have been?
Yes, sir. And my story is very typical. The sad thing is, it took almost 2 years for our home to start to display the problems. In other words, we built it brand new in 2006, and it was around 2008 we started experiencing the problems with the electrical systems, the air conditioning. My wife had the nosebleeds, the coughing, the headaches, all those types of things. And, homes that were built last year, there's a lot of people that have it in their homes, and they don't know it yet. Anything I can do, and that's one reason I wanted to come here today, anything I can do to bring awareness to this, it's hurtful to sit and tell people that I've had to file bankruptcy. May 17th, my home went into foreclosure. My wife and I were always the type of people, our mortgage check was there on the 1st because we were afraid if it was a day late, they were going to come take the house. I mean, here again, we've always done what we're supposed to do. And that's just what I hope, anybody that does business with this country will be held to the same standards as those of us that live here and work here.
Mm-hmm. Well, again, I want to thank you and the members of this committee. Our hearts goes out to you, and we are highly motivated to solve this problem.
Thank you, Chairman.
The chair is extending this time. Now the chair recognizes Mr. Whitfield for 5 minutes.
Thank you very much, and thank you all for your testimony. When we talk about safety of products in the U.S., of course, one part of it is we have a mechanism where we can recall certain items, and then what this legislation really is about is giving an individual or a legal entity an opportunity to get a defending party into court. And let's take Mr. Morgan's example, and Mr. Morgan, I also would like to convey my very much concerned about you and your family and what has happened to you and other people caught in the same circumstance. But if this law had been in effect, the one that we're talking about, and Mr. Popper, if we were able to get service process on this Chinese company that provided this drywall, and if we obtained a judgment in a court in the U.S., whether it's federal or state, whatever, how difficult would it be to actually obtain the funds to collect on the judgment?
I guess the best way to answer that would be to say that you'd never get to that question unless this legislation is adopted.
No, but
because you'd never get to having that manufacturer in court.
No, I understand that, and but if we're going to try to really help people like Mr. Morgan, we can help get service process very easily. But what can we do to collect on the judgment? In his case, for example,
the potential of liability changes behavior. The potential for civil liability is one of the most powerful forces in the American economy. Selling a product in the United States and knowing that you don't get a free pass or a dodge, but that you can be hailed into court and that you can be found liable, I think creates an incentive that's worthwhile. That's the whole theory behind the tort system. That's the corrective justice effect. I don't mean to avoid your question. But you start with the fact, you asked me how this could happen or how this could be avoided. That's one way. A second way is
how do we
the
collect the money? How do we collect the money?
You go after the manufacturer, and if the manufacturer doesn't cough up the money on the judgment, or if the manufacturer makes it difficult to secure that judgment under the Hague Convention, then you have to go after the distributor. But you don't get to do any of that right now. None of those values are there. To be clear, this legislation doesn't solve every problem in the civil litigation system when you're dealing with a foreign manufacturer. It does give you a valid starting point. This bill wasn't designed, as I read it, to facilitate the collection of foreign judgments. It allows for the entry of a judgment. Now, potentially you got a judgment creditor. You have a company that is in trouble. You have an enforcement mechanism through the Department of Homeland Security.
Thank you. I appreciate it. I only have a minute and 50 seconds left, but thank you for that. But the importer of this product, Mr. Baskin, this painted wallboard that was used in Mr. Morgan's house, would there be any mechanism through a treaty or otherwise that a lawsuit could have been filed against the importer or the distributor of the product in the U.S.?
The importer is responsible for obligations that the Tariff Act puts on him with regard to importation, but the importer would not necessarily be responsible for paying
Mr. Morgan, did your lawyer sue the importer of the product?
Not yet, no, sir.
Have they talked to you about doing that?
Yes, sir. I know all those things are being looked at, and I'd have to defer any additional questions like that to them, but
Okay,
yes,
so
sir.
they're looking at, then made a final decision yet, okay.
Yep.
One other question I would just like to ask, and I'm not an expert in this, certainly, but some experts have told us that this legislation may run afoul of WTO requirements for similar treatment of foreign and domestic products, that if the bill passed, foreign manufacturers would face the penalty of exclusion of their goods from commerce for failure to have a registered agent, and thereby accepting the specific jurisdiction of the state court. However, domestic manufacturers do not face this significant penalty of banishment from commerce for any similar violation. Is there any argument there that the WTO would look at this as a discriminatory type action?
I would have to defer to Customs and International Trade Commission for an answer like that. Yeah. CPSC wouldn't be in a position to answer.
But Mr. Popper, you had indicated that recently China had changed their tort law. Is that correct?
My understanding is, and it's in my testimony, that China adopted a new, what they call a new tort law, to take effect July 1, 2010. And
have you had an opportunity to look at that yet, or that law?
It's been in the making for 8 years, and I've looked at the component parts of it that are available online. I haven't read it in its native tongue.
Okay. May I ask one other question, and then I know we have other people, but Mr. Baskin, does the Consumer Product Safety Commission have a position on this bill?
Yes. We support the concepts of the bill, but as I noted in my testimony, there are some issues that we would have with regard to the range and size of manufacturers that would be subject to the process.
Okay, so you do support the concept?
Yes.
Okay, thank you. Thank you.
Ms. Sutton is recognized for 2 minutes. It's 5 minutes.
Thank you, Mr. Chairman. Mr. Baskin, in your testimony you stated that earlier this year Chairman Tannenbaum sent a letter to Congress, and in the letter noted that helpful changes to the existing statutes might include a service of process requirements for foreign manufacturers so that the agency can more easily pursue recalls. Is that correct?
Yes.
Okay. And so this legislation could be helpful to the Consumer Product Safety Commission as well as to providing redress for injured consumers, correct?
Yes.
Okay. Ms. Gadea, thank you very much for your testimony as well. The CPSC has a number of tools, as we've heard here today, intended to prevent unsafe consumer products from entering the market. And you testified that this bill will make considerable strides in assisting CPSC and other agencies in holding appropriate entities responsible for products that they introduce and sell to our consumers. Could you elaborate about how this would work together and complement the CPSC's activities?
Absolutely. As has been noted, there are mechanisms on the front end, such as the CPSIA and other statutes in place, that hold all manufacturers to certain safety standards that their products have to meet before they're sold in the U.S. And there are mechanisms, once those products come to our borders through the good work of CBP and Department of Homeland Security, to screen those products. But there's two issues with regards to that. One, not every company is going to follow those safety standards. You're going to have unscrupulous products, manufacturers, and products dangerous products coming through. And with the resources that CBP and others have, they're not able to screen every single one of the products at the border. So the end result, for a variety of reasons, is that there are going to be dangerous products on the market, despite everyone's efforts. And so this is yet another mechanism on the other side of things to address the harm when it does occur, and allows consumers, when they are injured and go through the devastating circumstances that Mr. Morgan and his family have gone through, to try to begin to obtain some redress for that.
Thank you. And of course, Professor Popper, you were just explaining the benefits of also having this kind of legislation passed, so that we can give an incentive to those who produce products to make them safe. Would you like to elaborate on that and how this is a useful tool up front as well as providing redress?
I think that there's no question that the potential for liability changes behavior. It means both making sure in the production process that you've exercised reasonable care and that in the distribution and sale process you provide adequate information and warning. You know that liability is down the road. Whether, as has been suggested, you may have difficulty collecting a judgment is a very separate question. The other piece of this is that once you interject the CPSC into the equation and the way the Consumer Product Safety Improvement legislation has worked, you end up with findings of regulatory violations where you don't have the collection of judgments problem. Those findings become facts that constitute a violation, they constitute a breach of a duty of care, and they are readily imported into our legal system. It's the way U.S. manufacturers function. They work both the front end and back end. It's what creates safer products. Why not do that with foreign manufacturers? Seems fair to me.
I appreciate that very much. Mr. Morgan, thank you so much for being here and for testifying, for sharing your experience with the committee in an effort to try and improve the situation for others. I'm very sorry to hear about what's happened to your family. I'm sorry to hear about the toll that it's taken and the time that you have had to deal with in pursuing some kind of effort at recourse. To the questions that some of my colleagues have raised about enforcement, I have some ideas about enforcement too, so I look forward to pursuing those. But I'm struck, and I think that it was Professor Popper who indicated that your words, frankly, summarize it when you say foreign manufacturers should not be allowed to sell products which destroy homes and make people sick with impunity, or the list of any of these other products that come into our stream of commerce. And frankly, it'll improve safety of products not just for American consumers, but for all consumers. And so I would advise and encourage folks to look at the list of items, Professor Popper, that is contained in your testimony, I believe, about things that are coming in to this country. And I don't have much time left, but I would just, because I'm not very familiar, Ms. Rowden, with exactly with your entity that you're representing, but I believe you said you represent the international trading community in the United States, and you support what I believe you described as fair and open trade policies. Did your organization support then things like NAFTA and CAFTA and PTR? PNTR,
yes, additionally,
PNTR.
we have supported free trade agreements.
So you supported all of those things?
Yes.
Thank you.
The chair now recognizes Commander Murphy.
Thank you, Mr. Chairman, and thank you to the panel. Professor Popper, a question for you. I just want to make sure I have a proper summary of your testimony. So if we use these products, you can be poisoned, strangled, choked, fall, crash, burn, bruised, or cut, or die, but you can't sue.
That's correct.
Okay. And then given that, then, I have a couple follow-up questions there. And you pointed out that when one has to face the responsibility of litigation, or the chance of litigation, it is a motivator for companies to make sure they're keep an eye on their products and because they're going to be held responsible for that. Does that add to the cost of products made in America such that products made in other countries that don't bear that responsibility use that as a mechanism to actually undercut the cost of products and sell them cheaper in the United States?
I'm not sure I understand exactly your question, but I believe in my testimony what I stated in the written portion of it was that foreign manufacturers who are freed of this responsibility bear lower costs because they don't have to observe the due care responsibilities, and they bear lower insurance costs, and companies in the United States do have to observe due care responsibilities, do have to observe statutory obligations, do have to insure against harm, and do spend more money. Consequently, the U.S. companies are definitely at a disadvantage.
And that's what I want to know, if you have any kind of a dollar figure, percent figure you have, that it's one of those things that foreign companies may actually, we know they manipulate currency, they do a number of other things to subsidize or manipulate taxes. But I'm wondering along these lines, too, if we have any kind of dollar figure of what it is that they may, by bypassing us, actually undercut the cost of products.
It's actually it's a wonderful question, and it's very volatile because it is what's referred to in the United States from time to time as the tort tax. If you listen in the tort reform debate to people who don't necessarily agree with me on some of the issues, and they complain about the imposition of liability, what they do is they place a percentage number on what it costs to produce good and safe products in this country and comply with our tort system. And I'm going to estimate that it's somewhere in the neighborhood of 15 to 20%.
But that's a significant number. And if companies are saying, well, we'll just build in China and send over here, and we don't have to pay that extra 15 to 20%, and we manipulate currency, which puts another 40% savings on, it's hard to compete with those countries.
It's hard to compete with those countries and with those products so long as those products are not subject to the U.S. legal system.
Thank you. Mr. Baskin, I have a question, too, on your testimony. Does the Consumer Product Safety Commission have sufficient personnel to screen these products before they even get over here?
That would be a question that would be outside of my range of knowledge here.
Well, I know you mentioned about the number of people who were involved with this, and you've increased the number of screening, which is good news. But even before they enter our ports, or I don't know where you feel it's more important to check them before they leave the country of origin or when they come to our country. It's one of those areas that, in order to protect consumer safety, if someone from your agency could get back to us, because it's an important question to know.
Certainly.
What we would need to do with that.
Certainly.
Can someone also answer the question of what happens to U.S. products in foreign countries? So if we send something to a foreign country and it is deemed to be unsafe or some other problem, what happens to those products from foreign countries? Anybody know?
I'll just give you a quick answer. Footnote 33 in my written testimony, I referred to a couple of pieces. One on the new Chinese tort law, and the other piece pertaining to South and Central America and the imposition of liability on U.S. companies doing business in foreign countries. And the record varies, but for the most part, I would kind of stand behind lex loci delicti. If you're in another country and you commit a wrong, the idea that the United States State Department is going to come in and bail you out when you're being subjected to civil liability, as far as I know, doesn't happen.
Okay. And one final question then. Do importers of products in this country, do they mislabel products in terms of country of origin, content, anything else? Is that showing up anywhere, Mr. Baskin, in your findings?
That is always an issue. I mean, I've spent some time in customs, and that is always a violation that customs would find. It would be no less applicable to CPSC.
Okay. Thank you very much. Thank you, Mr. Morgan.
The chair now recognizes Mr. Braley for 5 minutes.
Mr. Morgan, I had the opportunity at the height of the Chinese drywall publicity to inspect some homes in Delray Beach, Florida. And I got to see firsthand exactly what you were describing in your home. The corrosive effect on the wiring and the materials, the overwhelming smell of sulfur in there. And it was eye-opening for me because the homeowners were devastated by what was happening to homes that they'd put a lot of money and were very proud of. And then I went back to Iowa, where I live, and I was sick for about the next 6 weeks with respiratory problems. Have you or your family had any types of health-related problems because of being exposed to this Chinese drywall that we were talking about?
Yes, sir. My wife experienced nosebleeds for a long time, persistent coughing, the headaches. After we moved out of the Chinese drywall house into our rental home, she had nosebleeds for 2 days, and she hasn't had one since.
I think you're the perfect example of what foreign manufacturers who aren't subject to having a registered agent available in the United States do manipulate, and that is they know that the long period and cost of trying to hold them accountable for whatever they do, people will get frustrated and give up because at some point you have to move on with your life, and you can't wait for that magic solution when you've got bills to pay and people are pushing you into bankruptcy. Has that been your experience?
Yes, sir. I mean, it's just, just the cost, just to do the translation, $150,000, to myself or people like me, it might as well be $1 million. I mean, it's just money that we don't have, we can't afford, and being a police officer, I hate to say in public, thank goodness for attorneys. I mean, they've been a real lifesaver for us in trying to get some of our life back. It's just, it's been a maddening process. It really has.
Mr. Popper, I want to follow up with you. I have a very clear memory of a frontline program talking about the trade imbalance between China and the United States, and they showed the Port of Long Beach with shipping container after shipping container coming in with finished consumer products, a lot of them electronics, you name it, coming in. Then they showed what was leaving the Port of Long Beach, and it was recycled scrap metal and cardboard. That was the extent of what was going on in terms of the bulk of the shipping coming in and out of that port. And you talked about the practical aspects of enforcing a judgment against a foreign manufacturer. When you've got a judgment, all it is a piece of paper. It means nothing whether you're suing a domestic manufacturer or foreign, but it gives you the right to enforce a judgment. And if you've got assets available in the United States through a domestic manufacturer, you pursue that. If they refuse to pay or if they're not insured, you can levy on those assets, you can attach them, you can have them sold, and then those proceeds can be used to satisfy a judgment, correct?
That's correct.
Same thing applies with foreign goods that would be in this country coming in through our ports that are owned by a foreign manufacturer. Those are tangible assets that, if need be, could be levied upon to satisfy a judgment if you can trace them back to the owner of the manufacturer and they're doing business in the stream of commerce in the United States, right?
That is correct.
So it's not like we're developing a remedy without a payoff. It's just that it's very difficult, given the relationships with these foreign manufacturers and their ability sometimes to hide their assets overseas, that makes it difficult for people who've been injured by these defective products to actually get a payout at the end.
Yes.
Would you agree with that?
I would agree with that.
Ms. Gotti, one of the things I want to talk to you about is why this is so important. Because when you talk about something as massive as what we've seen with Chinese drywall, the average individual consumer by themselves are typically powerless against these large foreign manufacturers, many of whom are hard to identify. Because when you go into your Lowe's or your Home Depot, they may have a product there that looks on the surface like it's a domestic product, and in reality, it was imported by a distributor and being sold under their name rather than the original manufacturer. Why is it so important to consumers that we move forward on this legislation?
It's incredibly important because, first of all, I think consumers have an expectation, and rightfully so, that the products that come into their homes, regardless of where they come from, are safe. And it's only fair to domestic manufacturers that the rules that they play by should also apply to foreign manufacturers. You also need a mechanism that works on the other end of this entire supply chain in this system, where when you've got standards in place and you've got border protection in place, but you still have unsafe products coming through, sometimes you have a situation where you didn't know that this product was going to be problematic. I don't think anybody could have foreseen that you'd have a children's toy with a chemical on it that turned into the date rape drug. I don't think you could have foreseen years ago that you would have sulfur coming out of drywall and causing these kinds of horrific problems. You have a lag time between these products coming in sometimes and the problems they cause, and you need that redress on the other side for consumers to be able to be made whole.
Thank you. I'll yield back, Mr. Chairman.
The chair recognizes Mr. Sarbanes now for 5 minutes.
Thank you, Mr. Chairman. Thank you to the witnesses for their testimony. I always feel at these hearings in this particular committee that I'm always sitting here saying, you mean we don't already do that? Whatever the topic is, whether it's regulating chemicals, or in this case whether consumers are going to have recourse when these foreign manufactured products come into the country, because I think the average American probably expects that this is already being done. And in that respect, I want to thank Congresswoman Sutton for this legislation, because I think, as 4 out of 5 of you have testified, it makes absolute common sense to pursue it. I I once argued in the Fourth Circuit a case on minimum contact, so I'm very familiar with the frustration. It was a case called Elegant Machine Corporation, and we were down to trying to make the case that faxes and other communications that were coming into the state of Maryland were sufficient to establish minimum contacts for the purpose of exercising personal jurisdiction. I don't know if you're familiar with that case or not, but in any event, it makes absolute sense to try to fill this or close this loophole, as you've described it. And I wondered, though, if you could, Mr. Popper, respond to Ms. Cowden's arguments about whether we sort of don't need to go there yet, that it's really just a matter of improving the oversight through CPSC and other measures that we can take, and that this is just kind of an extra layer that is unnecessary at this time. If you could respond to that, I'd appreciate it.
I think about 2.5 years ago when we started learning about the problems with pet food and the entire country seemed to mobilize around the issue, your question was answered. Were you dealing with isolated incidents, isolated problems, and you had a solid regulatory structure in place, it might be worth waiting to allow that system to mature. I think that is not the case. I think you're looking at a remarkably broad problem. When you're talking about 80% or more of the goods regulated by CPSC, the vast number of our pharmaceutical products, goods throughout the United States that we use in good faith. And you started out your comment about, why don't we don't already do this. I think as a country, one of the best things about us is that we operate in good faith. We operate in trust. We believe that when we buy a product sold by a reputable seller, that we can rely on its safety and its efficacy. And we've learned with foreign manufactured products we can't do that. The regulatory system needs to be bolstered. The civil liability system needs to be bolstered. I certainly understand the desire to maximize our trade position. I think that's correct at every level. But requiring companies doing business in the United States, whether they're domestic or foreign, to follow the same set of laws strikes me as not inconsistent with that goal. It strikes me as perfectly consistent with it. And from my perspective as a law professor, I thank you for saying lawyers are from time to time heroes. They are, but you can be a good lawyer and representing a client who has a serious problem and run into exactly what you ran into in the Fourth Circuit, and there's nothing you can do about it. And when that happens, the concerns that we might have about some of our trading partners being miffed about the imposition of liability strike me as not particularly the dominant concerns that one ought to have.
I appreciate it, and I think, Ms. Gaudia, you made the point that even a very rigorous regulatory oversight regime doesn't mean that you're going to completely be able to prevent harmful products from coming into the stream of commerce. And you need other ways to create deterrence and or create some remedy or recourse should that happen.
That's absolutely correct. And in addition, as I mentioned in my testimony, this type of registered agent can also help agencies like the CPSC that are trying to conduct recalls within that regulatory scheme to do so in a proper fashion.
Right. I got 15 seconds. One last question for you, Mr. Popper, and that is, you spoke a little bit about what other countries have in place. Can you speak about what's happening with Chinese products going into certain other countries in terms of the way they're handling? I mean, because China's obviously been a focus of our discussion here. I mean, are we sort of in good or bad company, however you might want to characterize it, in terms of the way we are equipped to handle these products coming in from China when we look at other countries, or are others ahead of us on that?
To the best of my knowledge, we provide a remarkably generous environment for foreign manufacturers by not imposing liability. I believe in the EU countries and in Latin America and in South America, they are treated the same. as their domestic companies. And so I think what we're doing is both domestically and internationally leveling the playing field. And if I might add, just in terms of the regulatory obligations, keep in mind that as effective as regulatory systems are, they do not provide individual personal injury remedies. They provide a regulatory recourse. That affects the broad population, but the individual affected adversely by the violation of a safety regulation doesn't have recourse before the agency. The agency is in an Article 3 court. It doesn't provide those remedies.
Thank you.
The chair now recognizes Mr. Stupak for 5 minutes.
Thank you, Mr. Chairman. Thank you all for your testimony. Mr. Morgan, sorry about your problems there, and unfortunately your problems are duplicated many times throughout this country. Just a question, though. You said you had your house built, right?
Yes, sir.
Did your builder charge you the going rate for drywall, or did you get a lesser cost?
I don't know. I would like to know what the cost difference was.
Yeah, I would really like to know that, too. I mean, you might have a perfect claim right there against your builder.
Yep.
Okay. Let me ask Mr. Baskin or Ms. Gadea, what happens when products come in the United States, like this drywall? Let's say some came in right now from China, high in sulfur. What would happen to it? You discover it at the border.
Luckily, it's not. So that's a good thing in that.
But if it did, what would happen?
But if it did, it could be detained at
the
the border.
It sits there, right?
Yeah.
Why don't we just shove it back to the shipper?
The authorities allow that eventually.
They do?
Yep.
Okay. Well, then we had the inferior steel coming in from China, and we had a couple schools collapse in California because of inferior steel. They're telling us they have no authority to return it. In other words, it comes in, if they test the steel, doesn't have the proper strength, they set it aside, tag it, set it aside, and it sits there, or whoever ordered it picks it up. They're told they can't use it, say, for construction of school, but it sits there. Or they take it and use it for some other use, in theory. So while you have authority to detain it, you have specific authority to send it back to China?
I don't know about the steel situation.
Okay, well, how about drywall? Right now, if bad drywall came in, you have the right to detain it at the border. I agree with you. But do you have a right to send it back to China? And if so, who pays for it?
Good questions all. I would have to defer an answer to that.
Okay. Would you get an answer back to us on
writing,
that?
and we could get back to you on that.
Okay. Ms. Gadea, you indicated in Mr. Sarbanes that the registered agent could help in a recall. How would a registered agent help in a recall underneath this legislation?
In the way they would help is that you've got an entity here in the U.S. That should the agency need to get information from the agency about the scope of the product and when it was manufactured, the dates that they believe the defective product was manufactured, where the product went, how it was distributed, you've got an actual agent here that is, as the agent for service of process, a contact domestically for the agency. So they aren't trying to chase an entity overseas.
Sure, but 4647 just require you to have a registered agent here to accept process.
Mm-hmm.
You don't have to know anything about the product. You just have to be able to accept process, so you don't have to send it to China and try to chase someone down where the central government holds it for 6 months before they give it to the manufacturer. So how would a registered agent help? There would have to be more in this legislation, wouldn't there, to really help in a recall?
I think that what it would do is it gives the agency one more option, one more entity to try to get that information from, rather than sending it to China and having it sent back.
Right, I agree. If you're going to bring a lawsuit, you have a person, an individual or entity that you serve the process to, and that manufacturer, in this case of drywall, would be considered served. But I don't know how, by having a registered agent, how that would help in a recall, because they're not required to know the manufacturing location, physical location. You just have to be a registered agent for a company, right?
I might defer on the details of what the CPSC would be looking for as far as information in the recall process to the agency, but I think it would depend on the case. It would depend on, in some situations, the agent for service of process might be an entity that has that information. In some cases, you're right, it could be simply an agent that accepts the paperwork.
So in this legislation, shouldn't we expand the role of this registered agent more than just a person or entity who accepts service? Shouldn't they have greater knowledge of, at least, if it's going to help in a recall? I mean,
I think it could certainly help to do that.
Okay.
to expand it.
So would you
you've got-
suggest that we put that in this legislation?
I would respectfully take a minute I would respectfully respond that I would think about that a bit and get back to you on the record if that's all right.
Okay. Yeah, please do. I just, as Chair of Oversight Investigations, we see this all the time, whether it's melamine or whatever it might be, and a registered agent doesn't do anything to help you. In fact, all it is a point of contact here in the United States. Ms. Rowden, why wouldn't the American Association of Exporters and Importers just volunteer to be the registered agent for all these importers?
Oh gosh, because
I mean, you help
our
people.
members are importers and
Right.
exporters of goods.
Right.
Often it is the U.S. importer who has the legal responsibility under U.S. Customs law to deal with product safety, and also will ensure that
Wait, are you saying that the importers are certifying that the product is safe when they bring it in this country?
they have the obligation to make sure that that product,
Really? Under what
all
law is
US
that?
laws.
Under what law is that?
all laws, it's only not only U.S. Customs law.
So that Mr.
FDA,
Morgan should just sue the importer, right?
He can.
He can.
The question is, as a trial, I'm not a trial attorney, but whether that would, the causation would be there for the U.S. importer to be liable. I just don't know.
So the fact that they may have it, it's not real liability that Mr. Morgan could look to the importer of this drywall and say, aha, you imported this, you had a responsibility and duty to make sure to met U.S. standards, you did not, therefore, Mr. Importer or Miss Importer, you're subject to our courts and jurisdiction.
Certainly the U.S. importer is subject to U.S. law as a U.S. entity.
Sure.
They are subject to all the regulatory requirements.
But doesn't the law require them to knowingly know that they imported a defective product? And the burden of proof is really on Mr. Morgan, not on that importer to show that?
That would be a normal trial law.
Yeah. So it's really useless. So, but going back to my question, why wouldn't you just be the registered agent? I mean, all you're doing is accepting process. So therefore, you could cut down all the expenses. The fear of Congress putting forth regulations that you fear in your statement here, it could be resolved by your agency just being the registered agent. All you're doing is accepting process, and we could short circuit this, get right to the court, and see who has liability here.
But our association has no commercial relationship with foreign manufacturers.
You don't have to have a commercial
US
relationship.
importer.
All you have to be a person who's present in the United States over usually the age of 21 and be willing to accept a process. You don't have to be an attorney or anything. All you have to be is a person. You're the point of contact to begin that process so Mr. Morgan doesn't have to run all over China to find this manufacturer.
It is not our role as a trade association to serve as that function, because that's a legal function.
Well, I mean, if you're trying to promote trade, why wouldn't you do that? Because you're promoting trade, you're providing a service for people importing or exporting in. I would think that'd be a service you'd want to do.
I doubt that our membership.
I doubt you would too, but good argument. I yield back. Thank you.
The chair thanks the members, and also the chair thanks the witnesses for your outstanding and extraordinary contribution to this hearing. And with that in mind, we certainly, again, thank you for the valuable time, you allowing us to utilize your valuable time. This first panel now is dismissed. Thank you very much for coming, and Godspeed to each and every one of you. And Mr. Morgan, this committee does stand certainly in support of you and your family. Thank you very much. Will the second panel please be seated? This one ought to be pretty easy, the second panel. Will the second panel please be seated? This is social hour. We certainly want to welcome the members of the second panel to this subcommittee hearing. And again, I want to reemphasize to you how extraordinarily grateful we are for your sacrifice of your time and energy to be here to help make a contribution to the hearings of the subcommittee as we deliberate on these important matters. And I want to recognize each and every one of you by name. And to the members of the subcommittee, on my left is Ms. Mary Saunders. She's the Deputy Assistant Secretary for Manufacturing and Services for the International Trade Administration. Seated next to Ms. Saunders is Ms. Deborah Wentz Smith. And she's the President and CEO of the Council on Competitiveness. And next to Ms. Wentz Smith is Mr. Owen D. Hernstadt. And Mr. Hernstadt is the Director of Trade and Globalization for the International Association of Machinists and Aerospace Workers. And then next to Mr. Hernstadt is Mr. Jack Crawford, Jr. He's the Chief Executive Officer of JDU Power. And Mr. Anthony Kim is seated next to Mr. Crawford, and he's a policy analyst for the Heritage Foundation. Well, again, welcome to each and every one of you. We want it's the customary tradition of this committee to swear in the witnesses. So would you please stand and do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? Please let the record reflect that all of the witnesses answered in the affirmative. We will begin with you, Ms. Saunders. You have 5 minutes for opening statements.
Thank you. Chairman Rush, Ranking Member Whitfield, and members of the subcommittee, thank you for the opportunity to speak before you today about the important role and the topic of clean energy technology export assistance. As you're well aware, clean energy is the greatest economic opportunity of the 21st century. Promoting the development, production, and deployment of clean energy and energy efficiency technologies and services is a high priority for the Department of Commerce. These technologies are important to economic growth in the United States and globally. At the International Trade Administration, or ITA, we have identified significant overseas market opportunities for U.S. firms in these technology and services areas. For the record, I will not be commenting on H.R. 5156, but rather my testimony will provide a perspective on the issues, challenges, and opportunities within the clean energy technology and services sector today, as well as highlight some of the many programs that ITA has put in place to support U.S. industry competitiveness on this front. ITA is a lead export promotion agency in the federal government. Our mission is to create prosperity by strengthening the competitiveness of U.S. industry, promoting trade and investment, and ensuring fair trade and compliance with trade laws and agreements that enhance the ability of U.S. firms and workers to compete in the global marketplace on a level playing field. At his State of the Union address this year, President Obama announced the National Export Initiative, or NEI, with the goal to double U.S. exports in 5 years and support 2 million jobs. The President also emphasized that the nation that leads the clean energy economy will be the nation that leads the global economy. Clean energy technologies are a key way to meet global energy and economic development needs.
mitigate climate change, and capture the high-value engineering, innovation, and jobs that this sector offers. Within ITA, we are responding to the NEI and to the President's emphasis on clean energy by hiring trade specialists in emerging growth markets, supporting small and medium-sized enterprises to broaden their exposure to international markets, and developing outreach and trade mission programs to improve exports in high-growth sectors like clean energy. U.S. clean energy technologies and services companies face fierce competition in international markets. I want to highlight three factors that have a strong effect on international competitiveness: the strength of the domestic industry, the availability of international markets that offer U.S. companies a fair opportunity to compete, and the ability of U.S. companies to access the resources and master the skills required to export. The United States currently has a relatively small share of worldwide manufacturing capacity for clean energy-related industries. Nevertheless, there's a clear opportunity for the U.S. to lead the world in high-technology clean energy manufacturing. We can leverage the R&D and innovations being pursued by companies, universities, and the Department of Energy national labs into competitively competitively advantaged manufacturing positions. I apologize. U.S. clean energy technology exports cannot increase if protectionist rules and policies prevent open competition. Many countries have adopted policies that make it more difficult for foreign firms to compete in their markets. These include favoring their domestic industry through preferential tendering criteria and burdensome certification requirements. In addition, concerns regarding adequate protection of intellectual property rights also hamper some firms from entering foreign markets. Intense foreign competition from state-owned enterprises poses another challenge for U.S. companies, particularly in the civil nuclear sector. And the final challenge to increasing clean energy technology exports that must be addressed is the willingness of U.S. firms to export. In the clean energy sector in particular, companies face challenges to exporting that are not market or policy-based, but are internal to that particular company's knowledge and comfort with the export process. Issues include a shortage of available capital or financing, complex domestic and foreign regulatory requirements, lack of knowledge and comfort in local financial institutions to finance innovative clean energy products, and difficulty in finding a local partner or distributor. ITA has multiple clean energy initiatives in place to support the President's NEI and works in close collaboration with other agency partners. We have initiatives focusing on sustainable manufacturing and energy efficiency for U.S. companies, as well as a civil nuclear trade initiative that identifies the sector's most pressing trade challenges and opportunities and coordinates public and private sector efforts to address them. We're leading a trade promotion coordinating committee effort to develop an export strategy for renewable energy and energy efficiency technologies. And Secretary Locke recently established a renewable energy and energy efficiency industry advisory committee for industry to advise the department directly on pressing trade promotion and policy activities. ITA is actively promoting U.S. clean energy solutions in overseas markets through trade events, foreign buyer programs at major renewable energy trade shows. We've brought delegations from all over the world to these events. We've organized numerous trade missions focused on clean energy. Most recently, the Secretary-led Clean Energy Business Development Mission to Hong Kong, other cities in China and Indonesia. We have a number of reports and helpful resources, and I've brought copies of several of them. They provide a useful resource for small and medium-sized enterprises in the clean energy technology industry. And we recently released a smaller renewable energy market assessment report on Indonesia and have continued to hold informational webinars on diverse topics. Lastly, I wanted to highlight the Market Development Cooperator Program, which allows nonprofit groups or universities to propose projects to develop global markets for specific technologies. Last year, we awarded 3 awards in the clean energy sector. This year, we have received numerous applications for MDCP awards and are currently reviewing them. In closing, I'd like to thank you, Chairman Rush, Ranking Member Whitfield, and members of the subcommittee for the opportunity to highlight what ITA is doing to help U.S. companies compete in markets for clean energy technologies and for all kinds of U.S. goods and services around the world. Expanding opportunities to export clean energy technologies will not only maintain the competitiveness of U.S. companies, but will create jobs and generate economic growth. In addition, it will increase the reliability of our energy supply. American businesses have the technology, the expertise, and the experience to help countries around the world reach their climate and energy goals. And it's an extraordinary opportunity and a win-win for everyone. And thank you very much for your time today, and I welcome any questions you might have.
The chair recognizes Ms. Wynne Smith for 5 minutes.
Chairman Rush, Ranking Member Whitfield, and other distinguished members of the subcommittee, thank you for inviting me to testify today on the Clean Energy Technology Manufacturing and Export Assistance Act. This legislation acknowledges the pivotal role that the emerging clean energy industry will play in ensuring America's economic competitiveness and our national security going forward. The growth and vitality of this industry depends upon the development of a robust domestic market coupled to access to a burgeoning global market for these essential technologies and services that will take us to a low-carbon economy, energy security, and addressing climate change. Since 1986, the Council on Competitiveness has brought forth creative solutions to America's most pressing competitiveness challenges. Comprised of leaders from industry, academia, and organized labor, the Council is unique in its ability to build synergies and consensus across a wide span of organization and interests. Next week, on June 23rd, our chairman, Samuel Allen, the CEO and chairman of John Deere Corporation, will be launching with our members a new flagship initiative on U.S. manufacturing competitiveness in the 21st century. I submit for the record a summary of this initiative. The Council, with our partners in government and the private sector, will deliver a national manufacturing strategy to the administration and Congress at a national summit in 2011. And energy and the clean energy revolution will be at the heart of this agenda. Our Energy, Security, Innovation, and Sustainability Initiative, where we outlined a very robust plan last September, clearly supports and aligns with the objectives of the Clean Energy Technology Manufacturing and Export Assistance Act. As the 20th century drew to a close, rising global competition, the opening of global markets, challenged U.S. manufacturers, raising concern about the export of U.S.-made goods, offshoring of our manufacturing production, the loss of skilled U.S. manufacturing jobs, and a rising current account deficit, currency manipulation, and distortion. With the growing strength and consumer demand of the emerging economies, competitors such as China, India, South Korea, and Brazil, now there are many who fear that U.S. manufacturing will spiral into further decline. The Council believes that no nation can be a technology and economic leader without a robust multi-sector manufacturing capacity, and the stakes are extremely high. Our roadmap for energy security, sustainability, and competitiveness, DRIVE, highlighted that revenue in just 3 clean energy sectors, wind, solar, and biofuels, is projected to nearly triple over the next decade, and markets for clean technologies and their attendant services will expand exponentially. These markets and the jobs and economic growth that will bring our country to the forefront require a set of enabling policies and programs in research and development, in manufacturing, and commercial deployment here in America. So we believe that H.R. 5156 is an important policy step in addressing this challenge, and I'm pleased to be here today to voice our support for this proposal and legislation. But there are many more policy steps required to ensure a vibrant ecosystem that supports America's capacity. From next-generation R&D in batteries, storage, carbon capture, sequestration, and nuclear reactors, to increasing energy productivity and efficiency. We must engage in this intense global competition in Asia, Europe, the Middle East, and the Americas. As an example of what is at stake, within the past decade, the United States has fallen from 1st to 5th among top solar manufacturing countries and now imports solar cells from the EU and Asia. China now is doing assembly work for solar cells in the United States. I cannot emphasize enough the importance of taking a systems approach to our energy, sustainability, and economic policies. We have to understand the linkage between policies and how we integrate them into a holistic strategy. Everything from domestic tasks and fiscal policies to regulatory issues to, of course, global standards and trade policy. Let me highlight quickly 4 areas in our energy sustainability report that captures the essence of what you're trying to accomplish in this legislation with respect to expanding U.S. exports. The first is that we must remove tariffs and non-tariff barriers for sustainable energy products and services while not creating a dual track for preferential trade liberalization. We have to ensure that tariff reductions and removal of barriers are transparent, reciprocal, and provide access to all national markets where strong worker and consumer protections are provided. Two, we have to ensure intellectual property rights for all industrial products and services, copyrights, and sustainable energy solutions are protected. This is a huge issue with China, with India, with Brazil, and other parts of the world. Three, we must ensure our continued U.S. technological leadership for the breakthroughs and commercializations. The Council has proposed that we need a long-term stable source of funding, and in the future, we argue that 30% of any revenue from carbon pricing should be allocated to R&D, including the demonstration of clean energy technologies. And four, to ensure that the technologies of tomorrow will be manufactured in the United States, we should allocate 40% of revenues derived from any future carbon pricing program to manufacturing initiatives, federal, state, or local clean manufacturing zones, pilot projects, as well as immediate expensing and depreciation of the costs of retooling for production and qualified products, and dedicating high-performance computing assets to the clean energy manufacturing revolution. In conclusion, Mr. Chairman, the Council believes that the transformation to a low-carbon economy will unleash American innovation. It will create new industries, revitalize and rebuild manufacturing jobs across our nation, and keep and grow high-skilled jobs for this generation and the next. But we have to come together around an integrated manufacturing policy and to accelerate this growth, stewardship, and security for all. Thank you, and I'm welcome to answer any questions.
Thank you very much. Mr. Hernstadt.
Thank you, Mr. Chairman. The International Association of Machinists and Aerospace Workers is one of the largest manufacturing unions in the United States, representing thousands of workers who produce goods for exports every day. We strongly believe in the importance of the clean energy industry, and we welcome the opportunity to appear before you today. Support for domestic manufacturing goods related to clean energy is a critical component for our economic recovery, and it is urgently needed. U.S. workers continue to be mired in the economic crisis. While the official unemployment rate hovers at around 10%, the unofficial unemployment rate is approaching 20%. Some 8.5 million workers have lost their jobs since December 2007. With a significant number directly working in manufacturing. Today, there are over 15 million workers who are unemployed. Almost half of all those who are unemployed have been without work for over 6 months. The IAM continues to argue for the adoption of comprehensive policies that will address this jobs crisis. In order to be effective, we urge that these policies establish a framework for rebuilding our manufacturing base and ensuring its sustainability for the future. H.R. 5156, the Clean Energy Technology Manufacturing and Export Assistance Act of 2010, represents one element of an overall program that is so desperately needed. If enacted, the bill would assist U.S. companies in exporting clean energy products and services. The bill would also require the Secretary of Commerce to submit a report to Congress which would assess the extent to which the program has been successful in creating jobs in the United States. While H.R. 5156 represents an incredibly important step toward addressing the need to support manufacturing jobs in the clean energy sector, we urge an even more aggressive approach to ensure that federal support for companies to export clean energy technology and services does in fact result in the creation or maintenance of jobs here at home. A direct, verifiable requirement that federal support for clean energy exports results in the creation of U.S. jobs is essential. It appears that some companies are only too willing to produce clean energy goods and equipment in other countries. For example, as reported in the Washington Post, BP announced this spring that it would be laying off 320 workers and closing, quote, its solar panel manufacturing plant in Frederick, Maryland, the final step in moving its solar business out of the United States to facilities in China, India, and other countries. In making the announcement, BP's CEO stated that BP was, quote, moving to where we can manufacture cheaply. We offer 4 specific suggestions for moving ahead and for building on H.R. 5156. 1. Detailed employment impact statements should be a required factor in any decision-making process for government assistance. The employment impact statements would contain information pertaining to employment that would be mandated, created, or lost if the program in question were approved. We also suggest that capital equipment related to production as well as goods to be exported must be domestically made and contain domestic materials. Strong domestic content requirements uniformly implemented and enforced could be specifically contained in current legislation. Export assistance should also be sought through the U.S. Export-Import Bank, who has also developed expertise in these areas. And last but not least, domestic production for exports must be based on a fair and level field of global competition. Clean energy exporters must be able to prosper, and they can only do so if they're able and they're to compete fairly. That means trade barriers removed when dealing with countries like China. Those barriers must be challenged and removed. Demands for transfer of technology and production in return for market access must also be curtailed. Currency manipulation must be formally recognized and addressed, and relatedly, subsidies to the industry by other countries like China should also be challenged in a number of forums, including trade complaints. As mentioned at the outset, U.S. manufacturing workers are in a crisis, and not coincidentally, so is our country's economy. Promoting U.S. clean energy companies to export domestically manufactured goods with U.S.-made materials and products represents one important solution to this crisis. Again, we very much appreciate the opportunity to appear before you today and would obviously be happy to answer any further questions.
Mr. Crawford, you're recognized for 5 minutes.
Great, thanks. Thank you, Chairman Rush, Ranking Member Whitfield, and members of the Committee on Energy and Commerce for inviting me to speak here today about ways to increase global competitiveness of small and medium-sized U.S. clean technology companies. I would also like to thank Representative Matsui for her kind welcome and applaud her efforts to boost competitiveness of clean technology companies in the Sacramento area and the nation. I am Jack Crawford, Jr., the CEO of Jadoo Power, a small alternative energy technology company based in Folsom, California. I have the experience of starting, investing in, and growing several technology companies in my career. I would like to talk about the challenges facing a clean energy technology startup in its effort to market its clean products internationally. Jadoo Power is an industry leader in advanced power and energy storage solutions. Jadoo has used its technology to develop and deliver demonstration products to the military, government, and commercial sectors, such as portable power for medical devices to support wounded soldiers in war zones, emergency response communication solutions, and surveillance and security applications. Fuel cells, such as those manufactured by Jadoo, also advance the integration of other important clean technologies, such as solar, LED lighting, and wind power solutions. Whatever the energy source, fuel cells save energy and reduce emissions. Jadoo's technology is being productized for military and commercial uses, and additional support to scalar manufacturing will enable us to deliver a future large volume order of our products. It has been the case for many years that American science and engineering has been preeminent in the world. The U.S. is the unequivocal leader in energy innovation, just as we have been in such sectors as semiconductors, biotechnology, and the Internet. As we strive to become a global leader in clean technology, one area of innovation where our advantage is most threatened is manufacturing. Whereas breakthrough technology occurs here in the U.S., we are losing out to countries like China and Germany when it comes to energy manufacturing and exporting, in part because these countries are providing a host of tax incentives and other export financial incentives and advantages for their clean technology companies. Selling our clean energy companies to foreign markets will be imperative to the future growth and sustainability of the clean technology industry in America. Like all other sectors of our economy, small businesses are the cornerstone of the clean technology industry. However, when it comes to exporting products and services small businesses are at a disadvantage. Unlike large U.S. companies, small and medium-sized clean technology companies do not have the financial resources, the expertise, or the relationships to navigate through and succeed in foreign markets. According to the Trade Promotion Coordinating Committee, about 30% of non-exporting small and medium-sized companies would consider exporting if they had more access to international market information and assistance in pursuing export opportunities. Jadoo Power is one of those companies. This legislation being discussed today will help place clean energy technology at the forefront of our national export strategy and help small businesses find new customers and markets abroad. A greater level of support from the U.S. federal government would level the playing field, particularly for small and medium-sized businesses, and accelerate the ability of U.S. clean technology companies to meet global demand and better compete in the clean energy marketplace. I commend Representative Doris Matsui of Sacramento, along with Representatives Bobby Rush, John Dingell, and Ann Ashew for introducing H.R. 5156, the Clean Energy Technology Manufacturing Export Assistance Act of 2010. This bill sets out a national strategy to assist U.S. clean energy technology companies with export assistance to find new markets for their products and services and to better compete in the international marketplace. This bill also provides domestic manufacturing assistance to find new ways to reduce production costs and increase productivity in the clean technology sector. For Jadoo, H.R. 5156 would provide tangible benefits as the company works to advance its manufacturing of clean technology products and secure access and growth in the international marketplace. In addition to providing a robust business environment for Jadoo Power, the Sacramento region is well positioned to be a national leader in producing clean energy technology. Along with Jadoo Power, there are more than 100 other Sacramento-based small and medium-sized clean technology companies that would benefit from H.R. 5156, as well as other clean technology companies in California and around the U.S. Representatives Matsui and Lundgren, Governor Schwarzenegger, and Sacramento's Mayor Kevin Johnson have been actively supportive of clean technology companies, both locally, statewide, and their continued support will be important to this emerging industry, along with new support of government policies. The emerging global market for clean energy products is ever growing, and it is now time we look to market and sell our U.S.-made clean energy products to foreign markets. With the clear opportunity of clean energy technology, the United States can catch up and be a leader of the world with technology and American manufactured products. As we look at innovation and entrepreneurship in our country, it's time for us to both go green and go global. Thank you for inviting me to today's legislative hearing and allowing me to present my perspective.
And the chair now recognizes Mr. Kim for 5 minutes.
Thank you, Mr. Chairman. Chairman Rush, Ranking Member Whitfield, and members of the committee, it is my privilege to testify today concerning the Clean Energy Technology Manufacturing Export Assistance Act of 2010. My name is Anthony Kim. I'm a policy analyst at the Heritage Foundation. The views I express in this testimony are my own and should not be construed as representing any official position of the Heritage Foundation. In recent years, clean energy has become a shorthand term for the broad policy debate on how to achieve green growth and enhance our energy security. The proposed legislation offers a timely opportunity to discuss better ways to trigger innovation in our clean energy technology sector. Recognizing the urgency of developing a more competitive American clean energy technology sector, the proposed legislation intends to encourage innovation, investment, and productivity, particularly via federal subsidies. However, for the United States to regain economic leadership in the global clean energy industry, our strategy must be driven by real market conditions, not by government financial assistance that may serve as a temporary feel-good action and delay more meaningful advancement of the clean energy sector. Government-mandated funding has often resulted in unbalanced development and lasting government interference in the private sector, which dampen dynamic growth and innovation. It also invites the question as to whether government has the expertise to effectively help private companies navigate through rapidly evolving clean energy foreign markets. The proposed bill also fails to acknowledge that there are existing government resources and market incentives to increase production of efficient alternative clean energy. In advancing the competitiveness of our clean energy sector, there are more practical policy alternatives that can and should be implemented. At the top of the list should be further liberalization of international trade. Free trade fosters economic efficiency, and economic efficiency is the basis for innovation, growth, competitiveness. Over the past decades, the most practical improvements in energy efficiency and protecting the environment have not come from government-mandated funding. As shown in the analysis of the Heritage Foundation's Index of Economic Freedom, most progress has been driven by advances in freer trade and economic freedom. These unleash greater economic opportunity, generating a virtuous cycle of investment, innovation, and dynamic growth. Comprehensive trade liberalization provides the most efficient export promotion strategy. Such trade liberalization can be achieved by advancing freer trade through multilateral as well as bilateral trade pacts. Free trade agreements have spurred competition and economic growth. In recent years, the FTAs currently in force accounted for more than $1 trillion in two-way merchandise trade. FTAs also include provisions that safeguard American businesses from discrimination and protect and enforce intellectual property rights for U.S. firms. The pending FTAs with Colombia, Panama, and South Korea will result in significant new market access and lower tariffs for American businesses, including our clean energy producers. There is no doubt that accelerating innovation and production of clean energy technology has become an economic necessity for our future. The best strategy to make this happen is not through special subsidies, but rather through dynamic leadership in opening markets and spurring innovation technology. In conclusion, I want to emphasize that we need a strategy that conforms to conditions in the international marketplace, not one that struggles against it by subsidizing technologies that cannot stand on their own. We know one sure way of doing this, and that is through opening markets, not closing them with protectionist measures. Thank you again for the opportunity to testify before this committee today.
The chair thanks all of the witnesses for your fine testimony, and the chair recognizes himself now for 5 minutes for the purposes of asking questions. And I'm going to ask all the witnesses to answer yes or no to the following questions. Please, I only have 5 minutes, so if you could restrict your answer to yes or no, that would be very much appreciated. Seizing clean energy export opportunities could both accelerate the U.S. recovery and become an engine of growth. Would you answer yes or no? Beginning with the first witness, Ms. Sanders. I'm sorry.
Okay. You can't say yes.
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 Dollar for dollar, clean energy investments will create more jobs than investments in conventional energy sector, in the conventional energy sector. Yes or no?
I can't answer that officially.
It depends how you define clean energy. So I'm on the edge.
Yeah, I don't know. Well,
Dollar for dollar, clean energy investment will create more jobs than investments in the conventional energy sector.
I agree. It's difficult to answer without specifically defining clean energy.
It depends. Potentially, yes.
Okay. All right. Many of the new jobs created in the clean energy sector will be good jobs and provide good wages. Yes or no?
Yes, and particularly export-related jobs, which pay more than the average job.
Yes, because they take new skills and new capabilities.
I hope so.
Yes.
Yes.
Outside the U.S. borders, there is a promising market for U.S. green products.
Absolutely.
Yes.
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 Yes, sir.
Thank you. Trade barriers are not the only obstacles to increasing export of American products.
Yes, I agree.
Yes.
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 Last question. Other countries, especially our main competitors like China and other European countries and Japan, have a more aggressive export policy platform.
Typically, exports account for a larger percentage of those economies, and I would agree they strongly support the exports.
Absolutely.
It appears so.
Yes, and it's leading to a significant advantage for them.
Yes, I think they're in favor of free trade.
They also have policies that protect their domestic production.
In specific areas, that's correct.
Yes, for instance, China's new policy on indigenous innovation is very worrisome.
Yes.
Yes.
Yes and no.
Okay. The U.S. needs to have a more robust export assistance policy to its manufacturing industry.
We are operating within our current and appropriate levels, and we think certainly.
Yes.
Yes.
Yes, particularly for small and medium-sized businesses.
Yes, but to get there, it's open to debate.
Compared to other countries, the U.S. spends far less on export promotion. Yes or no?
It's hard to take an overall average compared to specific areas. The European Union, for example, that is correct.
Yes.
Yeah, I think particularly with some countries, I'm not an expert on the others.
Yes.
Yes, but I think it depends.
Yeah, okay. Thank you very much. The chair now recognizes the gentleman from Kentucky, Mr. Whitfield.
Thank you, and thank all of you for your testimony. We appreciate your being here today. And Ms. Saunders, I was just curious, you've been so generous with your time today, and you've testified, but you didn't testify. You said you were not going to make any comments about this legislation. And I was just curious, why is that? Why was that?
So the administration has not taken a position on H.R. 51.
Okay, so you all do not support it or oppose it. You have no position at this point. Okay. Okay. Mr. Crawford, I noticed in your testimony you were talking about, particularly in clean energy companies, particularly in manufacturing, that it's very difficult to obtain conventional financing. Is that correct?
Yes.
And is that one of the major reasons that you support this legislation, is because of the grant program that it would establish, the $75 million grant program?
Yes. I feel like as a country, between the venture capital investments and the stimulus program, we've seeded innovation and R&D around clean technology. Mm-hmm. We've gotten to demonstrable products, and now the next logical steps are to scale manufacturing and begin to sell those products both here and abroad.
Now, this legislation on page 3 says specifically that the Secretary shall administer the fund to promote policies that will reduce production costs. Is that it seems odd to me that we'd be using...
That's a significant issue for small and medium-sized companies, and here's why.
Well, I thought that you said that primarily you needed it for financing.
Well, part of investing and financing in the manufacturing process is to reduce the overall costs of producing those products. Okay. And so as you deliver demonstration units, they're oftentimes pretty expensive to manufacture, and the logical next step is to invest in and finance the manufacturing process to reduce the cost of those products so you can compete in commercial markets.
Mr. Kim, I noticed in your testimony that you seem to be diametrically opposed to what Mr. Crawford is saying. I mean, your general testimony seems to be you don't think the government should be involved in providing funds for a private enterprise to...
That is correct, sir. Not via federal subsidies. I think government can play a role, much bigger role, in fact, through free trade, through enhancing free trade agreements, be a multilateral or bilateral level. So there are certain things that government should and can do, but not through federal subsidies.
So you think the free trade agreements will play a vital role?
I think clean energy, especially, I think free trade is really vital. For example, the current pending U.S.-South Korea FTA, South Korea is a huge market for green energy technology.
In fact, I noticed that you were pretty stringent on this point. You said the proposed legislation fails to identify specific policies to be pursued and risk becoming little more than a financial subsidy grab bag for politically connected special interests.
To be a federal subsidies, there's no monitoring mechanism we can follow. So I think we'll have to see how this bill actually implemented, and then actually the entire process regarding dispensing federal money will be processed, but there's a debt risk, political risk, and then potentially we can invite some other problems too.
Mm-hmm. Mr. Hernstat, I noticed that you all certainly, your union certainly favors the intent of this legislation, but I think you're specifically saying that it does not go far enough. And one of the things that you mentioned that needed to be done was to any grant that goes to any company, that there be an EIS, as you call it, an employment impact statement, which actually I think is a pretty good idea. Have you all been successful in getting EIS requirements in other government programs?
Not yet, but we're still trying. I think it's a really common sense solution to what we're talking about. It really started off with an idea dealing with government procurement and the billions we spend on it. The government should know what it's getting for its money, and if a specific program is directed towards creating U.S. jobs, we need to be able to calculate that with precision, and that's something I'm not sure the Commerce Department is doing yet, or really any federal agency.
But, I mean, it sounds like that would certainly improve this bill from your perspective.
I think it's one area that would, but I want to also point out that the bill itself is a real acknowledgement that there's a link between clean energy and U.S. jobs, and I think that by itself is a real step forward.
I know I only have 3 seconds. One other question. Mr. Crawford, the Ex-Im Bank, of course, is very much involved in exporting technology, environmental technology, all products abroad. Has your company utilized the Ex-Im Bank for any of its...
We haven't. My perception is the difference here is we're talking about a focus on one particular industry sector that's of critical importance to our country and small and medium-sized businesses. So the combination of those two things with this policy would not only provide us with access to greater expertise focused on our company, but also a set of relationships that could be helpful in getting traction in the international marketplace.
Thank you, Mr. Chairman.
The chair now recognizes the author of the bill, Ms. Masui, for 5 minutes.
Thank you, Mr. Chairman. Thank you all for being here today. As I mentioned in my opening statement, my hometown is Sacramento is home to 110 clean tech companies. Many of them are small and medium-sized companies who are just now exploring ways to expand their businesses by exporting their products to foreign markets. But as you know, unlike large companies, they don't have the resources, time, and manpower to effectively promote their products abroad, and they do need the assistance. And I do know that many of them have, asked for help with Department of Commerce, small business, and all other entities that we could all think about. But I particularly have a question, several questions for Mr. Crawford. You're being a small business person. Is J2 Power currently looking to expand by exploring ways to export your technology products abroad?
Yes, we're looking at new markets and in particular looking at international markets.
Okay. Now, as a small business person, what are the current barriers that you face in exporting?
Access to expertise and how best to export products, relationships, and just effectively resources, the time.
So how do you go about it now?
right now it's independent market research. It's trying to identify people who have expertise in international marketplaces. It's consultants. It's research on the internet. It's those types of efforts.
Okay. As you know, this legislation authorizes about $50 million a year for 5 years. Now, as a small business person who's really concerned about, expenses and resources, do you feel that this legislation is this amount of money is a responsible use, and so that this country can actually establish a national clean tech export strategy to boost the competitiveness of small and medium-sized businesses?
Yeah, as a small business owner and as a taxpayer, I think you can make the case that this is one of the best uses of taxpayer money. I mean, what we're talking about with regard to our company and others in the Sacramento region and likely others across the country is something that can impact our energy security, our environmental security, and have a positive impact on our economy. Those are driving issues in our country today, and this is the type of bill that could have a positive impact on taking small companies effectively that are the cornerstone of our economy and growing them. So my question actually is why aren't we as a body considering 10 or 20 times the amount? Because this is something that's addressing all the relevant issues of today.
Okay, thank you. Ms. Saunders, do our international competitors like in the EU and Asia help their small and medium-sized businesses, particularly clean tech businesses, facilitate exports to the U.S.?
Yes, they do.
How do they do that?
They do that through export promotion programs very similar to the ones that we operate out of the Department of Commerce and other trade agencies.
But they have more emphasis on it?
As I said earlier, specific countries in the European Union and other parts of the world have exports are a larger percentage of their economy, and they allocate a large portion of their government resources to promoting those exports.
Okay. If this legislation were enacted, what are your rough estimates on the amount of increased U.S. clean tech exports in dollar amount or in other measurements?
We can always do more with more resources. We believe we're actively servicing this industry as a current priority of the Secretary and the administration. As far as dollar amounts, it's difficult to speculate as technology and services and actual products being exported have different values assigned to them. I would say generally from the International Trade Administration, we have data that estimates that for every dollar invested in International Trade Administration programs, we generate $56 worth of exports.
Okay. Let me see. Deborah Winsmith. Now, the President has repeatedly stated that he wants the U.S. to be the leader in exporting clean tech to other nations. However, international competitors like China and Germany are exporting substantially more clean tech energy products. I know we look at turbines and fuel cells and solar and all of that. In your opinion, would this legislation provide the tools and resources to boost U.S. clean tech firms' competitiveness in exporting their products and services?
Well, like my colleagues, I believe it's a very important first step. And, many of the provisions in the legislation, in addition to the grant program that's been mentioned, are really to accelerate the tools, the practices, the networks that small and medium-sized businesses need. I think one of the other issues that we really have to address still is how do we stimulate the production in the United States on a viable scale that it can go out globally. And, that's a very, very serious part of this because in order for these new clean tech innovators to have a scale, they really have to have access to deep equity and debt capital. And that gets into our whole broader set of issues.
Understood. And I think Mr. Crawford has been experiencing that himself. But as a small business person, you are excited about the fact that we are having a focus on clean tech exporting, as I understand, because it is part of the picture, so to speak. It's not the complete picture, obviously, but it is part of the picture. Anyway, I thank you very much, and I yield back the balance of my time.
The chair thanks the gentlelady. The chair thanks all the witnesses who have participated today in today's hearing, and the chair particularly thanks this panel. You've been very patient with us, and you have been very giving in your time and your contributions as it relates to your expertise. Some of your statements have been very provocative, and certainly we will take all your statements to heart as we proceed with this legislative process on these particular concerns. The chair really thanks you and appreciate you very much, and we hope those of you who travel, we ask for traveling grace for each and every one of you. Thank you, and God bless.